Back here on February 13th at 9 o'clock. Stay in touch with Mr. Klein.
Yes, sir.
Thank you, sir.
Christmas, okay? I'll call you.
Mr. Stewart?
Good morning, Your Honor.
Good morning, sir.
May it please the court, Your Honor, Brad Stewart. I'm covering for Mr. Bo Powell, Judge, on behalf of Stefan Shorts. This is 22 CF 3118, judgment before the court with regards to the motion to modify sentence. The request ultimately is to allow Mr. Shorts to pay off the 50 hours of community service work. Judge, I believe it would be most appropriate to swear Mr. Shorts in for some brief testimony.
Okay, Mr. Shorts, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Good morning, sir. Please state your name for the record.
Stephen Shorts.
Are you employed?
Yes, sir.
Where are you employed at?
I'm a private chef for 3 different companies.
Okay, and what kind of hours do you work doing that?
Anywhere from 12 to 16 hours a day.
And how many days per week?
4.
And how is your family life structured around that schedule?
The days that I have off, I'm usually at home with my son, my 1-year-old son, as my fiance goes to work.
Okay. So would it be fair to say if you're not working, you're taking care of a 1-year-old?
Correct.
And does that provide you opportunity to perform community service work in this regard?
It does not.
Would you have an opportunity to pay the community service work?
Yes, sir.
Nothing further, Your Honor.
Any questions from the state?
Yes, sir.
Please.
Mr. Shorts, what did you do for a living on August the 12th of this year?
I've been a private chef for the past 5 years.
Did you work for the same 3
Yes, sir.
companies at that time,
No, one. I just picked the other 2 companies up just recently.
just recently?
Probably about when I first got on probation.
Okay. So, this was a negotiated plea, right? You went over this with your attorney?
Correct, but I wasn't, I was never been told that I wasn't able to pay off my community service.
When you saw that the requirement for probation would be 50 hours of community service work, what did you think that meant?
Well, anytime I've ever been on any type of probation before, I was able to pay it off, so I never thought of it that I wasn't able to pay.
Nothing further.
Thank you. Any redirect?
No redirect, Judge.
Okay. Argument?
Your Honor, based on Mr. Short's specific schedule, working 4 days a week, anywhere 14, 15-hour days, with regards to his family life as well, I don't believe that there's a reasonable opportunity for him to complete 50 hours community service work. I think the request to buy that out is reasonable given those factors and circumstances.
Thank you. To the state?
Your Honor, as I was alluding to in the question of Mr. Shorts, this was a negotiated plea between Mr. Shorts and his attorney and the state. 50 hours of community service were specifically added as a sanction, which is a punishment for behavior, specifically illegal behavior that constitutes a felony. The contemplation was that Mr. Shorts would complete the 50 hours of community service work, and perhaps that would help him to avoid in his free time obtaining and using illegal narcotics. And hopefully that would, be some type of deterrent there. This is a situation where he works 4 days a week. He said it's going to be hard for him to do it. A sanction and a punishment is supposed to be hard for you to do. Let's just say that he was charged with DUI, which he wasn't. That would be a misdemeanor. Not only is there usually a sanction for 50 hours of community service work in that situation, but there's also a driver's license suspension. Now, the Florida Department of Highway Safety and Motor Vehicles, they also impose a vehicle impound when you get that. Now, they're not going to impound a person's vehicle while the license is suspension, which is another sanction. Why? Because he's not allowed to drive, or he or she wouldn't be allowed to drive during the suspension period, so why would they impound the car? Because it's got to hurt. It's supposed to create a situation that's difficult, and that's exactly what the intent of the 50 hours of community service work He's self-employed. If he has the money to buy out community service, then he has the ability to take a couple hours off a week and work for the greater good and perform some community service. I believe he would have an in with his boss if he's self-employed. So I would assume that when he was out with the illegal narcotics, that his child wasn't with him. So there's some time where he doesn't have custody of his child, that he has some free time apparently. So it's not unreasonable for him to follow through with and be required to complete the sanction that he signed up for. And we believe is appropriate in this situation. Thank you.
Thank you. How long is the probation? What was the original term?
3 years, I believe.
Ma'am? Okay. Mr. Shorts, it's always interesting to the court. I agree with a lot of the things that the state said. If somebody's a multimillionaire and it's just nothing for them to pay off the community service hours, you wonder what deterrent effect it has, for them. Probably very little. Very seldom is it brought to the court just dead on like this case is. I did look at the charge that you pled to, possession of controlled substance. I listened to your testimony where you said previously when you were involved with the legal system that you were always able to pay it off in the past. I do like the deterrent effect of working community service hours. So respectfully, your motion, and because the term is 3 years, your motion to modify sentence is denied. Thank you, sir.
Thank you, Your Honor. That's all I have before the court.
Thanks, Mr. Stewart. Oh, thank you. Mr. LaPella,
I'm not ready, Your Honor. I need to talk to Mr. Snell.
let me know when you're ready. Okay. To the PD folks in the gallery. Or any attorneys on Zoom, any private counsel? Don't see anybody jumping up. Ms. Sandler, what case are you on?
Your Honor, I'm here on Tavion Morris. I've spoken to Mr. Cobb this morning, and he's on his way to court.
Okay, good. Thank you, ma'am. Is Seth McDonald present?
He's right here, Your Honor. Oh, yes, sir.
Okay. You ready, Mr. McDonald?
Yes, sir.
It's 22 CF 778.
Your Honor, the state spoke with probation just a few minutes ago. Based on that discussion, I believe he's actually ahead on payments for cost of supervision. Given that, Your Honor, we're going to agree for the motion to early terminate probation.
Okay. Mr. McDonald, it was worth your time. I'm glad that you sent me the letter.
Yes, sir. Did you actually get the chance to read it like yourself?
Absolutely. I read it, highlighted it.
Yes,
I
sir.
do my homework. At least I try to always do that.
I was wondering that. If there was
And that's what prompted this hearing. I read it and I said, set it for a hearing.
Thank you, sir.
So I appreciate you doing that.
I appreciate you guys, seriously.
Your probation, your supervision is terminated.
Thank you.
Thank you, sir. Merry
Happy
Christmas.
holidays, man. Have a good one. I
You
heard it's
too.
your last day, too.
Yeah, last day on full day criminal. Yes, sir.
Yes, sir. Well, have a good one. It was a blessing, man. Thank you.
Thank you, sir.
Thank you all. Absolutely, sir.
Next is Akila Mitchell. Don't see Miss Mitchell. David Oliver. Don't see David Oliver. Michael Wicker. Nope. Okay, then I think the rest are, Mr. Kleins, would you like to start?
Your Honor, Jason Neely.
Good.
There's Ethan Rasco out in the audience. He says that Mr. Keys is not coming to court.
He said he had
He's,
it's cold.
Oh, so he's coming after that?
He said that he's gonna try his best.
We filed he filed a stipulated motion to continue that case. I told him I didn't have an objection. He's double booked. I believe he might be in Walton County this morning.
thank you. Right, I did see that.
Mr. Rasco, you can come on up.
Sorry.
Mr. Rasko's case is 23 CF 2642. I did have notes, Mr. Rasko, on my docket that said, motion for continuance filed, plea entered on 5/20/24. JB to sentence, me to sentence, question mark, and then I had, so I was interested in how today was going to go because I didn't have more homework on your case. So I guess that's why I put the question to myself. Am I going to sentence Mr. Rasko, or is Judge Stone going to do that? Have you talked to Mr. Dees about that?
Basically, we've texted each other, and today is like a really difficult day on his calendar. He just couldn't figure out how to fit it all in. And
Just in the future, since I'm rotating off the bench, either we have to figure out when to do that, and unless you want to do it a week from today, I'll be on the bench at 12:30. But that's the day after
Can I let you know
Christmas.
this afternoon? Because I will try to get in touch with him when we break after a while and see if that's possible for him.
Okay, is that good for you? Are you going to be here?
I'll be in town, yes, sir.
Okay. So, Mr. Rasko, I'm going to set it for a week from today at 12:30, but stay in touch with Mr. Dees. That very well may change.
May the defendant and I approach?
Certainly.
But we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Hi, I'm attorney Michael Gilbert, and from all of us here at Warrior Law, we wish you and yours a safe and happy holidays.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Thank you. So, Mr. Rasko, I'll see you on December 26th,
Bakery
the
Cafe
day after
is 2
Christmas at
blocks from the courthouse
12:30.
on his Crestview
However, that may be
historic Main
continued.
Street.
Stay in touch with Mr. Dees. Thank you, sir. You too.
Your Honor, this is Mr. Jason Neely.
Yes, sir.
He's before the court on some arraignments on 4 different cases. We will enter denial today, ask that this be set on the February 13th docket, just for the court's and the state's benefit. We have already reached out to Phoenix House and are in the process of securing his treatment records from that program. So they should be arriving in the mail sometime in the next week or maybe 2. But we are already working to try to resolve this, so.
Okay. So when do you want it set?
February 13th, Your Honor.
Okay. But if the state offers you something, Mr. Neely, that you want to accept before that date, Mr. Clines can set it for a lot of times before then, okay? So no later than February 13th. Also, if you're still incarcerated on February 13th, Judge Stone is taking over this division next month, and he has, from what I,
Judge, that's miscellaneous.
nope,
day,
that's
so-
different. Okay. You'll be in front of Judge Stone on February 13th. Good. Thank you.
Quentin Peterson, Mr. Cox.
Thank you.
Good morning, Judge.
Good morning, sir.
Your Honor, this is Mr. Quentin Peterson. We're here on two cases, 23 CF 1940 and 24 CF 2585. If I may have a moment.
Yes, sir.
Signature.
Judge, just for the court's awareness, I'll be getting a score sheet to you later on, maybe this
Okay.
afternoon or tomorrow.
Good. Thank you.
Okay. Have you sign right there. And today is the 19th. Thank you, Your Honor.
Yes, sir.
Your Honor, this will be a change of plea this morning. In 23 CF 1940, count one would be admit to the violation. This will be the 11 months, 29 days in the Okaloosa County Jail. Of course, credit for time served. There's the $100 cost of prosecution, $250 in defense costs, and probation will be revoked and terminated. In 24 CF 2585, counts one and counts two, adjudication of guilt. This will be 11 months, 29 days in the Okaloosa County Jail for credit for time served, $515 in court costs, all cases and counts to run concurrent. If I may approach with the signed plea form.
Yes, sir. Thank you. Mr. Peterson, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Peterson, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Peterson, I do accept your plea. You're adjudicated guilty in each case and count. Your prior supervision is revoked and terminated. You're sentenced to 11 months, 29 days in the Okaloosa County Jail, and that's to run concurrently, run at the same time, and that's with credit for all time served. You'll need to pay a total of $250 public defender's fee, $100 cost of prosecution, and the court cost. How long will you need to pay? Probably about $850. After you get out of jail, how long will you need?
6 months.
Okay, you got it. Thank you, sir. Good luck to you.
We have Victor Ruano Human with Mr. Weaver and the interpreter.
Okay, good. Thank you. Hello, Mr. Weaver.
Morning, Your Honor.
Good morning, sir. You're on the arraignment docket? What
We're
docket?
here for a status conference.
Okay,
We've been
good.
able to reach a negotiated plea.
Great, thank you. Got it. Yes, sir. Madam Clerk?
Do you agree to accurately translate from Spanish to English and from English into Spanish all matters brought before the court? Thank you.
Thank you.
Initial here. Just put your initials. Right here. Okay, all right.
Yes, sir.
Thank you, Your Honor. So, Your Honor, the state has filed an amended information in this just yesterday. I'm not sure if it's made it through the system yet, but he's been charged with 2 counts of felony battery. And we have a negotiated plea agreement. May I approach?
Please, thank you. Thank you, sir.
So I do see that there is an amended information, but it does not have a subsection. So there's an email sent to the state regarding that.
A subsection?
Yes, sir.
Okay, it doesn't have a subsection. What does that mean? He's got counts 1 and 2, but what do you mean by no?
Count 2 doesn't have, well, they don't have the subsection included in the statute.
Oh, gotcha. Okay, the statute number for the charge?
It should be on the score sheet, Judge. I believe I handed
Okay,
that to you.
here we go.
Let me approach you if I could with the score sheet, Your Honor.
Yes, sir. Good, thank you. Charge itself, not the statute.
Your Honor, I notice it
Yes, sir.
does have the statute of 784.041. There is no subsection. Quite frankly, Your Honor, this is a compromise resolution for this charge. And it would be hard to point to one particular subsection to apply since, quite frankly, it's a compromise resolution.
Okay, and this is a negotiated plea, so that's the reason for the downward departure, correct?
That's correct.
Okay,
And also, I would argue, just for the record, I don't know if it matters, but I think paragraph 3 of the mitigators applies and 5 applies, but it doesn't really matter if the court's going to depart. And
Mr. Human, if you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. Mr. Human, was the plea agreement read to you? Do you understand it? Did you sign it?
Yes.
So, Mr. Human, I'm going to go through what the sentence would be and make sure that that's what you intend, okay? So if I accept your plea, you would be adjudicated guilty. You'd be sentenced to 5 years probation on count 1, 5 years probation on count 2, and they would run consecutively, one after the other, for a total of 10 years with no early termination. You would need to submit to a sex offender evaluation and any treatment if it's recommended. You'd have no unsupervised contact with any minors, and no contact with the alleged victim unless the alleged victim requests contact through probation. You'd have to pay court costs of $867 and $40 per month cost of supervision. Is that what you understand? And you agree to that? Mr. Human, I do accept your plea, and that's what your sentence is. Thank you, sir.
Your Honor, could we just put something on the record that we understand that probation is going to run starting today? It's possible that he could be deported. INS has a hold on him, and we don't know what's going to happen, but we understand that if he is deported, probation would continue to run, and he would have to report if he comes back into the country in the next 10 years.
Any objection to that?
I'm sorry, Mr. Weaver, can you repeat that?
I just said that we understand probation is going to run starting today, and if he gets deported, he would have to, if he comes back in the country, we have to report the probation in the next 10 years.
Is that typically how probation will handle that situation? Okay, then I have no objection.
Okay, thank you, sir.
I verified all that through probation, so we
Good.
just want to make sure it's clear on the record. There's one other issue that we're requesting that his phone be returned to him. I may need to file a motion because I don't know who has it, whether the jail has it or the sheriff, and I understand there's no objection as long as there's not contraband on it.
As long as there's no contraband, we have no objection to the owner of the phone coming to get it from the sheriff's office.
Okay, and I may have to do that on his behalf if he's deported.
Okay. Mr. Weaver, do you want this blank form back? You handed me that. It's a
Oh, I'm
blank
sorry.
plea form? No, that's fine.
Well, yes, I did.
Okay.
Thank you.
Yes, sir. Thank you, sir. Merry Christmas. Okay.
Show in the system that there's two possibilities.
Okay, Madam Clerk saying she still needs a subsection. What are the two possibilities?
Subsection 1 and 2A.
1 and 2A.
Because we haven't been able to update the case adding the second count because it's incomplete.
It would be 1. I do believe the score sheet said with great bodily harm, so that would be 1.
Good, thank you. Good, thank you, ma'am. Thanks, Mr. Weaver.
Thank you, Your Honor. Have a great day.
You
Merry
too.
Christmas.
Merry
if I don't see you.
Christmas. Yes, ma'am. Good, please. Okay, thank you.
Your Honor, this is Mr. Wilfredo Rivera Gutierrez, 24 CF 2650. I know the information has been filed, Your Honor. Oh, excuse me for a minute. We do have a copy of the information present. We'll be entering a not guilty. Waive formal reading. And my client is set for the January pretrial docket, Your Honor.
Okay. Mr. Gutierrez, Judge Stone will be your judge next year. If you're still in the Okaloosa County Jail on January 15th, they'll transport you in front of him. If you get out of custody before January 13th, you'll need to be here on January 13th at 9 o'clock. Thank you, sir.
And next we have Domingo Sebastian, also with Mr. Cobb.
Thank you. Good morning, Mr. Sebastian.
Buenos días.
What is this?
All right, good morning.
Good morning.
Your Honor, I'd first like to clarify my client's name and date of birth on the record. Can you please state your first name?
Do you want him under oath?
Oh, I'm sorry, yes, Judge, please.
If you please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Lo juro por Dios.
Thank you. You can put your hand down.
Could you please state your first name?
Domingo.
And can you please, Domingo, thank you. Can you please state your last name?
Sebastián.
And your date of birth?
24 de abril. del 2004.
2004.
April 24th of 2004.
Abril 24 del 2004.
Thank you.
Yes, sir.
Your Honor, receiving the information will be entered not guilty, waive formal reading, and my client is set for the January pretrial docket.
Mr. Sebastian, Judge Stone takes over this division next month,
Oh, no, the 116.
so you'll appear in front of him on January 15th if you're still in the Okaloosa County Jail. If you're released from the jail before January 13th, then you'll need to be here on January 13th at 9 a.m. Thank you, sir.
Thank
Yes, sir.
you. You take that, yeah. See.
Thank you, ma'am. Merry Christmas. Okay.
David Oliver, who you called earlier, who has no attorney.
Okay, good. Mr. Oliver. Thank you, Rachel. Mr. Oliver's case number is 20 CF 602. Mr. Oliver, if you'll give me a moment, let me look at my homework. Good. You sent me a letter, and what I highlighted was requesting an early release from probation.
Yes, sir. Your Honor, the state spoke with the probation officer in this matter, and the holdup the last time that this occurred was that we wanted to make sure that the firearm had been forfeited. That was an issue in this case. We got that confirmation, and so at this time, the state would have no objection to early terminating probation.
Okay. Mr. Oliver, your supervision is terminated, so you're not on probation anymore. Probation?
Your Honor, can you waive his outstanding COS and arrearages in order for that to happen?
I do. I waive your arrearages. Yes, sir. Merry Christmas, sir.
Thank you.
Thank you. Thanks for the letter to the court.
Thank you.
You're done.
Your Honor, this is Mr. Quentin Purnell in 23 CF 2186. If I may have a moment,
Yes, sir.
please. Your Honor, this will be a change of plea of no contest this morning. I first want to notate count 1 is going to be the lesser included offense of burglary of an unoccupied structure. That's Florida statute 810.02, subsection 4, subsection A. The terms of the plea will be an adjudication of guilt. This is a guideline sentence of 14.7 months, Department of Corrections. Credit for all time served, followed by 3 years of standard probation, $40 per month cost supervision, condition of probation to successfully complete Haven House program, which will be bars to bed. There will be $515 in court costs, $150 defense costs, and reserve restitution for 90 days, Your Honor. And I am asking the court if we can waive the $40 per month while my client is at Haven House, Your Honor.
Good. Yes, sir.
If I may approach the plea form, Ms. Horsey.
Yes, sir. Thank you, sir. Mr. Purnell, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Purnell, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Has anyone forced, threatened, or coerced you into entering this plea?
No, sir.
Do you have any questions for me or your attorney or the state?
No, sir.
Mr. Purnell, I do accept your plea. You're adjudicated guilty. You're sentenced to 14.7 months with the Department of Corrections with credit for all time served. That's followed by 3 years of probation. When you say basically bars to beds, I don't know if I've ever heard of a bars to bed from prison to a facility. The prison's going to hold him, or is the prison going to transport him back to the Okaloosa County Jail until a bed becomes available?
If I may, Your Honor?
Please.
My client does have the 14.7.
Already in.
Already in. If we can stipulate and hold them, and I'm going to notify Haven House immediately this morning.
To the state, you stipulate that Mr. Purnell's already served 14.7 months?
That wasn't really discussed, Your Honor, so the state's not going to stipulate to that at this time. We'll let the jail decide the credit.
Okay. Mr. Purnell, I'd rather address things now that may be a problem rather than
Yes, sir.
you sitting somewhere or being released from prison and then they say you violated because of whatever.
Yes, sir.
To the state, have you ever seen that before? Does the prison hold Mr. Purnell until a bed's available?
I've personally never seen that before. That doesn't mean that it hasn't happened, but I haven't seen it, Your Honor.
Okay. Mr. Koch, your homework, because I don't want to hold up Mr. Purnell going about his business. So your homework, one, is to see if the state agrees with you that Mr. Purnell's already served all his time. And if you can stipulate to that, then give me an order immediately and I'll sign that, okay? And then in that order state, however, he'll be held until a bed becomes available at Haven House, okay? If that's not true, that he still has to go to prison, talk to people at the public defender's office, find out if anybody's had this situation before. If you want me to sign an order that outlines what happens, says the prison will hold Mr. Purnell, but if he gets out before a bed becomes available at Haven House, then he goes to the Okaloosa County Jail, whatever, and if we need to have a status hearing after that, then set it with me,
Yes,
okay?
Absolutely.
I just don't want you to get caught in that gap, I'm concerned.
I understand. I appreciate it.
Yes, sir. You'll need to pay the $40 per month cost of supervision. That'll be waived while you're in Haven House. As a condition of your supervision, you'll need to enter and successfully complete Haven House. You'll need to pay the court costs, $150 public defender's fee. The court does award restitution, but reserves jurisdiction for 90 days to determine the amount of that restitution if the state files a motion or a petition. You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights? Thank you, Mr. Purnell. Good luck to you, sir.
Are these Riley's next? Are these counts running concurrently?
Yes. I didn't know how many there were. Yes, ma'am.
Yes, Judge.
Good morning. Good, how are you?
This is Mr. Kevin Riley, Your Honor, 24 CF 2530. We have a bond motion scheduled this morning, Your Honor.
Okay. Let me see if that was added, and I don't know if I've done my homework on that, so you may give me a minute. I have not. So I'm looking at the paperwork from the first appearance, the first appearance information, which shows the risk assessment 15, doesn't show any other felonies. Looking at the arrest report.
Governor, may I approach with
Yes, sir.
Mr. Koch?
Sir.
We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Mr. Riley, so the state
CQ Roofing, your hometown roofer since
is
1999.
stipulating to a
We're state licensed.
$3,500 signature bond for you. So you'll be able to sign out of jail today without posting any money. Make sure you stay in touch with Mr. Koch. Is Mr. Riley's case, when is that set for?
January 13th.
Okay, so you need to be back here on January 13th at 9 o'clock.
Thank you so much.
Thank you, sir.
Is that 3,500 signature on each count?
Hey, how many counts are there? We'll do it on each count. Yes, ma'am. Thank you.
Next, we have Roger Bryant with Mr. Cobb.
Hello, Mr. Bryant. Good, how are you? Good.
Good morning, Judge.
Good morning, Mr. Cobb.
Let's go ahead and proceed with the bond motion, and then I need to talk to Ms. Sharpless about something.
Okay. And here's, Mr. Bryant, when I was doing my homework reading through that, here's what I highlighted. Arrested on November 14th of 22, manslaughter charge. The drugs the defendant allegedly sold to the victim were not found at the victim's residence, and then set a $500,000 bond. I did highlight some things in the arrest report that said October 31st, 2018, went through drug paraphernalia located on the bed next to the victim, an autopsy report. The victim's cellular phone was located in his pants, in his pant pockets. On October 30th of 2018, victim, and I read the rest of it, but the victim sends Bryant a text, "I'll come see you with cash on lunch break tomorrow if it's cool." Bryant allegedly replied, "Okay, I need it. My funds are tied up in some cream." Then on October 31st of 2018, the victim asked Mr. Bryant if he had any boy, common slang for heroin, and then they have the replies to that. I read the balance of those communications. Yes, sir.
Yeah, Judge, I understand there are those text messages there. At the time, we have filed a notice of alibi witnessed Mr. Bryant was present in Pensacola for the birth of his son. So although there might be some text messages back and forth between Mr. Bryant and the victim, there's absolutely zero direct evidence that any type of seller transaction ever took place. And again, of course, the bond motion that I filed cites the medical examiner saying the death was an accident caused by overdose. There is actual testimony from depositions of family members and others that the victim was buying illegal substances from numerous people, and at the time of his death, he was taking numerous substances, and there's no direct correlation that anything was ever sold to the victim from Mr. Bryant that caused his death. He's been sitting in jail for almost 2 years. It's the defense's position that this is an overcharge by the state, and I don't even think they could get to a jury if we went to trial. I think this is one of those situations where we might possibly get a JOA. There's a lot of supposition, innuendo, and speculation, but there's no direct evidence linking the death of this person to anything that Mr. Bryant actually did. It's just all based on supposition, circumstantial evidence, and speculation on the part of the state. So I'm asking that the bond be reduced from $500,000 to something less. Of course, $500,000 is no bond for Mr. Bryant. And really, he's been in jail for so long that he has actually zero financial ability to make any bond. So those are the arguments based on.
Thank you. To the state, Ms. Sharp?
Yes, Your Honor. Good morning. Thank you. So the things that the court pointed out are the things that the state wanted to also note. But to begin, I think the court should understand that this is not a first bond hearing for Mr. Bryant. We have had a previous bond hearing where the deceased victim's family testified. And just to reiterate, they did want Mr. Bryant held on the bond that was set at first appearance. It's of note that when this was set at first appearance and when we have had a subsequent bond hearing, that probable cause continues to be found. There's been no motion to dismiss or anything like that set, Your Honor. So the state wants the court to note that there's been no change in circumstances from the state's point of view. The evidence that Mr. Cobb pointed out in his motion and the court has just pointed out has been the evidence from the beginning. The evidence against Mr. Bryant has not changed except for that now that Mr. Bryant has Mr. Cobb, which it has been within the last 6 months or so, that there is a potential alibi witness, which the state does have a deposition scheduled of at the Okaloosa County Jail on January the 3rd. Mr. Cobb did let the state know that when he came on the case after he spoke to Mr. Bryant, that there was a potential alibi witness. Mr. Cobb did then work to get a private investigator to see if there was anything to that. That did take a while. So just prior to this last pretrial conference, he did file a notice of alibi. The state has set the deposition. It will hopefully be taken on the date that it's scheduled for. The state knows the general idea of what that witness is going to say, but the state does not know if there's any direct proof that Mr. Bryant was actually at the hospital at the time these drug transactions occurred. Your Honor, the thing the state wanted to point out was that I think inadvertently the bond motion makes it seem like there is no evidence that Mr. Bryant dealt the deceased victim the drugs that killed him, when in fact the text messages do prove that Mr. Bryant was the last person to have contact with the deceased victim, and that there was a drug transaction that did occur shortly before the deceased victim was found dead. So there is evidence that Mr. Bryant was the narcotics dealer that dealt the deceased victim the drugs that killed him. Again, the evidence against Mr. Bryant has not changed, except potentially there is an alibi witness, which the state, again, does not know exactly what that alibi witness is going to say, which is exactly the reason that depositions need to be conducted, and then we'll go from there. I understand that Mr. Bryant has been in jail for a while, but Mr. Cobb is not his first attorney. Things are moving forward to either a resolution or a trial the way they should be. Depositions are scheduled the way they should be. Things are moving forward, Your Honor. So at this time, the state would ask the court to deny the bond motion and keep the bond set as it's been set.
Okay. Mr. Cobb, what I'm thinking about doing is denying the motion without prejudice, meaning that after the January 3rd deposition, you can bring it back before the court. I think that's the best way to do it, rather than me, because you make those arguments in your motion, and I think those facts would mean a lot to the court.
Yes, sir.
Okay.
Might I ask this? I know that you're getting ready to transfer out. That's too bad for us, but you have another date next Thursday, which is like the 26th.
I do.
If I can work out something between now and then.
Can I sing?
Ms. Sharpless, that can resolve this case.
Hold on one. Yes, sir.
Can I contact the clerk and put him on the docket and get it?
Absolutely. If there's anything with any client, I've got that whole afternoon. As long as the state, you can get them enough notice where they can do their homework. If it's a bond motion, if it's a plea, get me an order that says transport, do whatever.
Yes,
But absolutely.
And Your Honor, I don't know if we can work it out, but Mr. Cobb, of course, if his client has a counter offer the state needs to know about, we will discuss that, and if we can work it out, the state will make itself available next Thursday for, if a plea can be entered.
Okay.
I can't guarantee it, though, Your Honor.
I understand.
But I will speak with Mr. Cobb about this.
So the motion's denied without prejudice.
Thank you, Your Honor.
Thank you.
Merry Christmas.
Merry
That's
Christmas.
all I have
Thanks,
with
Ms.
the court.
Sharpless.
Can I be
Yes, ma'am.
excused?
Absolutely. Thank you, ma'am.
Manuel Colley is next.
Judge Brown, just really quickly, because
Yes,
it's
sir.
going to be very quick. Akilah Mitchell, I was looking into her case on the clerk site. I think this will be a quick one. She had just written because she had received a CAPIS. This is 12 on my docket, 22 CF 2606. She had received a CAPIS, and she has been incarcerated in the Houston County Jail. She actually sent a letter in the mail from the Houston County Jail. And so, Judge, I think at this time the proper thing would be to withdraw the CAPIS for her. I think that was what she was requesting in her letter. And then just, I think, leave her set for her next court date.
Okay, so the capias on Ms. Mitchell, which is 22 CF 2606, is withdrawn. And this is a new case?
I think she's just been.
Yes, sir.
A new case. Okay, so then it'll be set on the pretrial docket for January 13th at 9 o'clock.
Thank you, Judge.
Thank you. Yes, sir, Mr. Cobb?
Yes, sir, Judge. This is State of Florida versus Emmanuel Colley. In, I guess, two cases, 2019 CF 2948 and 2024 CF 1008. I believe it will sit on the docket based on correspondence that the court received from Mr. Colley concerning my actions and also concerning a conflict of interest that the defendant says Mr. Alderman has in the case. So I believe we're here today to deal with those issues. I will tell the court I spoke with Mr. Colley yesterday at the jail, and I feel like him and I have resolved any issues that we had, or we're on the same page now. The meeting of the minds, that's taken place. I am going to file a motion for Brady disclosures because I feel like there might be some Brady evidence that hasn't been turned over to the defense. And again, I've only had the case briefly. And in a capital murder case, when I get it, of course I could go based on what everybody else has already
Okay,
done.
let's stop a second.
Okay.
Mr. Colley, you're the reason why we're here. Your letter that you sent to the court, I read it. I highlighted Mr. Cobb, talked about the state attorney, spoke about witness me commit inside the courtroom something, spit on the public defender. Mr. Cobb completely ignores me or ignored me. He hasn't come to speak with me, has not done so, hasn't fulfilled what he said he was going to do, not taking me seriously. So those are the reasons why I said, let's set it. You got to tell me what you want to do. If you still want me to determine whether Mr. Cobb is rendering ineffective assistance of counsel, I'll put you under oath and we'll take testimony. but you got to tell me what you want.
Well, first, I really want to address with the state attorney, dealing with that, because at the end of the day, you know, he did earlier this year in 2024.
Okay, let me stop you. As far as the state attorney, I don't think you have the ability to say that the state attorney has a conflict. If you've got an attorney, that attorney is the mouthpiece to the court. If they want to file a motion, then the court will rule on that motion after a hearing. The reason why you get to talk directly to the court is you're saying, under this, the way that I took it was, my attorney's rendering ineffective assistance of counsel, and so you need to replace him. And that's something that I need to determine directly from you. As far as the state, you can't just jump up and say, I think the state has these conflicts, and you need to rule on that, Judge. Your attorney would have to present that to the court. Okay?
Well, yesterday, like you said, we did speak. We did address some issues, and at the end of the day, I agree with him putting in the motion about dealing with the Brady violation, but I still would like him to still try and put a motion in to suppress. And I understand that he has been doing this a lot longer than I have, but I've still brought things to his attention, and for him to come up and see me, it showed me that, hey, you know what, I'm looking into it, I'm seeing it, and that's what I have been looking for.
Good, good. I had to smile when you said, I brought some things up to him that he basically didn't know or hadn't addressed yet. Before I went on the bench, I was an attorney and went to a continuing education, and it was an arena setting, all litigators, and the person came in that was speaking, an attorney, from lunch break and slammed his hand down on the lectern and yelled, "Shut up!" And all of us, and he did it again, and he slammed his hand down and said, "Shut up. Shut up and listen to your client. They'll win the case for you." So that's good that Mr. Cobb is listening to you, because you live this case. So that's good. So I'm taking that you're withdrawing any possible motion for me to make that determination against Mr. Cobb. That only covers the past, okay? If something happens in the future and you believe that he's not doing what he's supposed to be doing, then you can certainly refile it, okay? When will Mr. Colley be back in court?
I believe you said on the January pretrial docket, Judge.
Okay. So if you're still incarcerated, Mr. Colley, you'll be back on January 15th in front of Judge Stone, okay? Thank you, sir.
Yes, sir. Thank you.
All right, thanks, Steve.
Thank you, Judge.
Thank you, sir.
Judge, I know that I see Ms. Sandler's on the
Good.
Zoom. So we could go ahead and do the Morris if you wanted to,
Okay.
if that's all right.
Yes, sir.
And he's incarcerated in Escambia County. But he's in Escambia County Jail. I've spoken with Mr. Morris about this, and I've talked to Ms. Sandler about the case. I just did get mailed 2 weeks ago an external hard drive that I purchased and sent to the state, and it has a lot of additional stuff on there that I haven't looked at. I'm going to spend the holiday going through it and looking at it, so hopefully at the January 15th pretrial, I'll be in a better position to announce to the court, Judge Stone, where we are and if I need to do anything else to move forward. So
Okay.
we're just tracking for January 15th.
And this is 22 CF 1809. So where is Mr. Morris?
He's in the Escambia County Jail.
Okay. And you're waiving his appearance for
Yes,
today?
sir, I am.
Okay. And you'll let him know the outcome of this case?
He
of
probably
this
will
hearing?
find out the outcome before I even get back to
Okay.
my office, Judge.
Good,
So-
good. Ms. Sandler, anything else you want the court to know?
Nothing from the state, Your Honor.
Okay. So Mr. Morris will be before the court on January 15th.
Thank you.
Good. Thank you, Ms. Sandler. Do you have any other cases?
I do not, thank you, Your Honor.
Thank
Have
you,
a Merry
ma'am.
Christmas.
Merry Christmas.
Judge, this is State of Florida versus Kyle Scott.
Yes, sir.
And 2024 CF 1900, 2024 1906. I set him on the docket today because I was hopeful that Mr. Snell and I could have a plea worked out and we could resolve both his cases. We're fairly close. Mr. Snell's got some additional things to do with regards to a score sheet, so the state does not have a plea offer for me today. If Mr. Snell and I work it out, I'll contact the clerk's office and get it set, but right now it's going to have to stay on the January docket for pretrial.
Okay, Mr. Scott, I'll be on the bench a week from today, so if the state offers you something that you want to accept before then, knowing that Christmas is the day before that, so, but Mr. Kopp can get you before me then. If not, you'll appear in front of Judge Stone no later than January 15th. Okay?
Yes,
Thank you, sir.
There's no way we can offer the state anything to get it solved today? Or?
I've tried, but Mr. Snell's got some homework to do before he can consider what I've offered. It's just not feasible to get it done today.
Okay. Thank you, sir. And Mr. Cobb, on this motion, or the order that I signed says on December 19th for a plea or a continuance, and I thought that was funny.
Okay. This is State of Florida versus Rico Williams. He has 4 cases, 23 CF 1332, 23 CF 1913, 24 CF 115, and 24 CF 1493. Again, I set this on the docket because I was hopeful that Mr. Snell and I could work out some type of agreement. Mr. Snell and I have been in communications. We've taken depositions in the cases, so we know the relevant facts. The only case that I haven't really delved into yet is the fraud case I just got appointed on a couple weeks ago. But right now, the state's not in a position to make an offer that I can, well, they're not in a position to accept the offer that I proposed.
Yes, sir.
We're still working on it. I hope I can get Mr. Williams' cases resolved.
I want to get it resolved.
Yeah, I want to get it resolved as well.
Today.
Yes, sir.
It's not feasible to get it resolved today because we're not in a position where the state can say yea or nay with regards to the offer.
So to the state, you need to do some additional work?
We do. I can,
Please, I need it. I'm trying to get to the field house for it.
I don't know that we could do it on Thursday.
I don't want to put Mr. Snell on the spot because I realize how much he's got going on as well, and plus it's the holidays. If something can be done on Thursday, I'll contact the court. If not, I'll
Good.
get it done as soon as I can.
Okay.
So,
Mr. Williams, if the state offers you something that you want to accept before next Thursday, knowing that Christmas is the day before that, then I'll see you a week from today. If not, then you'll appear in front of Judge Stone on January 15th. Okay.
Get it over with.
Yes, sir. I can't make the state offer you something no more than I can make you accept something. So I've got to wait and play the hand I'm dealt. Okay.
same with me as well. I've been working, trying to get something resolved, and, I think we're in communication, talking is good. So hopefully there's hope. That doesn't make any sense. There is hope. But if I can get him back in, I'll do it, and we'll plead him out.
Okay. Thank you, Mr. Williams.
Both of those cases were set on the 15th?
Yes, the natural.
They're probably technically set on the 13th, but it's my understanding that they moved them a week before from the 13th to the 15th if the defendant is incarcerated. You'll be back in front of Judge Stone if you're incarcerated on January 15th. If you're not in jail, then you need to be back here on January 13th at 9 o'clock. Okay? Thank you, sir.
Eileen, you get this?
Thank you.
Judge, this is Ms. Yepes present for the court in 2 cases, 2024 CF 432 and 2024 CF 2023. She's currently held on a $35,000 bond. That's a combination of both. Part of that bond is set based on a trafficking charge in 24 CF 432. But like I said in the motion, as of the date I filed the motion, I haven't seen any FDLE reports indicating that there is a trafficking weight or an amount, or that the drugs that they seize have even been tested. So based on that, I'm asking the court to reconsider the bond and lower her bond based on the fact that right now it appears just to be maybe even a possession, but we don't even know that because there's no labs back yet.
Okay. To the state.
Well, I think her bond situation is not necessarily based on the charge being a trafficking charge or a possession charge or distribution charge. She was charged with trafficking amount of methamphetamine and possession of a couple of other controlled substances at the time. The interesting thing was that was earlier this year. Of course, the situation surrounding all that indicated distribution of narcotics, and the meth weight was over the trafficking amount from when the arresting officers waited. The bond situation is based on the fact that when she was charged with trafficking, she had a $29,000 bond, and then at some point earlier this year, Mr. Cobb filed a motion to modify and ask for a signature bond instead of having to pay her cash or professional on a trafficking charge, and the court agreed and gave her a signature bond. While she was out on the bond, she just picked right up and continued with the same behavior. She was arrested again with multiple baggies of narcotics, scales, baggies that hadn't been used yet, all of the signs that she's continued to distribute narcotics in our county. So the court revoked the bond that she had for the trafficking charge. So it's, to say the bond situation is really based on the fact that it's trafficking and we don't have a weight yet, we don't have the report yet. That's not really what the situation is. The situation is she's going to continue to sell and deliver drugs in our county when she's out on bond, and the state would object to that. Now, Mr. Cobb did let me know that he was looking for that report, and yesterday I sent out a request to FDLE to find out what the status is. So I'll get that to him, shortly. But at this point, I don't believe that it's the state's position that her bond should not be reinstated, based on she's not willing to cease and desist the criminal activity.
Ms. Yepes, when I was doing my homework, I read through the motion for bond reduction. I also read through the 2 first appearance information sheets from February of this year, and then the 8/25, and the arrest reports in there, and had different things highlighted in there. I understand Mr. Cobb's argument as far as that delay in FDLE, but I've got to make my determination based on just the evidence that I have, which are the sworn statements of the officers. Mr. Cobb knows what he can do if he believes that there's too much of a delay with FDLE. I can't give him legal advice, but he knows that avenue. You can go to trial. At this point, I understand what his argument is, and I don't like that delay either. But I'm not going to base my bond just based on that delay. So respectfully, your motion for a bond reduction is denied, so there'll still be no bond on that first case. Okay.
And just for her benefit, Mr. Snell and I are in discussions. We've talked about resolutions in this case, and I'll continue to work with the state to try to resolve it in an amenable manner so that she can get out of jail.
Okay, good. Thank you, Ms. Yepes.
Judge, I believe those are my cases.
Thank you, sir.
Can I approach?
Yes, sir.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For
Yes, sir.
all of
Mr.
your roofing
McKinnon.
needs, call us today or
Certainly.
visit our website at cqroofing.com.
Ms. Wiggins is before the court.
CQ Roofing, your
for
hometown roofer.
24 CF 10, and this is a case in which Ms. Wiggins is already on probation. She
She's also on probation in the second case number. The second case number is 23 CF 2778. I really set this on the docket as a friend of the court, as it's not in violation status, and it's not even really an open case. But she had reached out to my office and indicated that there was an issue related to the substance abuse treatment. Originally, back in March, when she pled to a withholding probation, it was stated that it would be ECLC, the Emerald Coast Life Center, that would be doing the outpatient in Holt. That's become issues with transportation since she lives in Fort Walton, and she's already set out to move that to Bridgeway, and has everything set up to move on December 31st. But to do that, the court would need to modify her supervision to delete ECLC as outpatient and then add the substance abuse evaluation and treatment right back onto the probation as a condition.
Okay, to the state?
The state would not object to it's, I guess, the only thing that would be modified would be the treatment provider, but the actual conditions would stay the same.
Correct.
Yes, sir. Ms. Wiggins, is that what you wish to do?
Yes, sir.
Okay, I do modify your supervision to delete ECLC and add the requirement for a substance abuse. Has she already been evaluated?
Yes, sir.
Okay.
I believe she's set up to start that on December 31st,
Yes.
and she's been in communication with her probation officer.
Okay, and so that start where? Bridgeway?
Bridgeway.
If we can include it as a condition that just says substance abuse treatment, then Bridgeway would certainly suffice for that.
So you'll need to submit to substance abuse treatment and begin that no later than January 15th, okay? If it's December 31st, that'd be great.
Yes.
Okay. I did read your letter. Thank you for that.
Thank you.
You're living down the street at One Hopeful Place?
I'm actually back at with my family.
Excellent. Congratulations.
Thank you.
That's excellent. Merry Christmas, ma'am.
Thank you. Merry Christmas.
Thank you.
Thank
Thank you for being here.
Next is Elisa Rios and Aloza. Mr. Koch.
Thank you. And then after that, Ms. Goodson, I'll take your case.
Judge, this is Elisa Rios Penaloza in 23 CF 318. I set her on today's docket for two reasons. She did not have a court date. This is a violation of probation. She didn't have a court date in the future, so I definitely wanted to make sure she gets on the docket.
Good.
And I also wanted to ask the state if there was a potential offer this morning.
Your Honor,
Yes, ma'am.
the case hasn't been reopened because we're still showing that the order committing arrest is outstanding.
Okay. Mr. Koch, Madam Clerk said that the case is still closed because she hadn't been served.
We're not showing proof. We don't have an arrest report showing that she was served.
And Judge, I know that my office reached out to the jail and asked them to serve the order of arrest, because, but I believe that has been served, so I'm trying to figure out where the disconnect is.
We don't have the paperwork.
Okay, so you would need the paperwork from the jail?
Yes, sir. That's how the procedure works.
Okay, so you were served on the 9th? From next report. Okay. So I believe that Mr. Koch's office or my office can reach back out to the jail and try to get that paperwork to Madam Clerk so that the case is formally reopened.
Okay.
Because I know that she's been in jail since October.
Okay. Let's presume that the paperwork gets to the clerk by noon today. Then what happens with her case? What do you,
Normally, the clerk would set that for the next miscellaneous date, which is not until February.
but I didn't know if the state and the defense were working on anything.
I've reached out for offer, Your Honor. She does have a new law, misdemeanor. I was hopeful to get
Right.
an offer this morning.
It says it's set for a hearing. What type of hearing did you set it for?
I just set it to, because I wanted this on the docket in the future, or at least make it aware for the court's attention, because I don't want my client just to disappear, but, you know.
Well, and the reason why it's not on the docket is because the case is technically closed. Don't you love that? And you're in jail, and Okay, so you're going to follow up, make sure that the clerk gets the paperwork where she can open the case back up. If the state offers you something that you want to accept, Mr. Koch, do you have any feel from the state about whether you may be able to work out something? If so, do we want to hold her until this afternoon?
Let's, if we can, hold it this afternoon, Your Honor.
Okay. So I'll see you after 2:30 this afternoon. Okay? Thank you, ma'am.
Thank you.
Okay, Miss Gooden.
Good morning, Your Honor.
Good morning, ma'am.
I was a little confused whether I had court with you or not on a Jessica Musselwhite, Musselwhite, 24 CF 1665.
Okay, I don't remember doing any homework on Ms. Musselwhite. Is she on for today?
Yes, Your Honor, she is on the docket, if I may. I believe in looking at the clerk, because I was trying to figure out why she was on the docket as well. If I'm not mistaken, her last court date, she appeared with no attorney, and she informed us that she was hiring Ms. Gooden or had hired Ms. Gooden. And then you wanted to set a status just to make sure that that was in fact the case, to make sure that she did retain an attorney, Your Honor.
Okay, good. And I had a question mark when I did my homework on my docket the same way you did, Ms. Gooden. So, Ms. Gooden, you do represent Ms. Musselwhite?
Yes, Your Honor. We filed a notice of appearance.
Super. Okay, so is it set for January 13th?
Correct. And hopefully the state and I will be able to resolve it by then.
Okay, good. Well, thank you. Thanks, Ms. Gooden. Thanks for appearing, and you'll appear in front of Judge Stone on January 13th.
Thank you, Your Honor. And if I don't see you, Merry Christmas.
Merry Christmas. Thank you, ma'am.
Thank you.
Okay, next, and don't forget the folks that are on Zoom to counsel. Okay, is it Mr. Barnes?
Yes.
Mr. Barnes, if you'll unmute your mic and start your camera.
There we go, Judge. Can you hear me?
I can. Thanks, Mr. Barnes.
Very good. Thank you. Judge, I've got Sean Muldoon. I believe he's in my office appearing by Zoom. If he isn't.
There you go.
Okay, wonderful. Judge, this is a violation of probation. The underlying case is, the underlying allegation is a new law violation in Escambia. And that case came up for its first docket day 2 weeks ago. The state, we were headed to trial. The state listed a witness late. We had to continue it. It's reset for February 25th. There is an offer. I have not gone over that with my client. But right now, the status is February 25th docket day. 2 weeks later would be the trial, and the deposition of this newly disclosed witness has been set.
Okay, so Mr. Muldoon, do you want me to set it? Judge Stone has dates February 13th, February 20th, but the next date that would be after your February 25th date would be April 17th. So is that when you want me to set it?
Yeah, I think you said, Mr. Muldoon, I think you were talking to me, Judge.
I'm sorry. Sorry, Mr. Barnes.
No, that's fine. That's fine. I certainly have been called worse. Yes, April 17th would be wonderful, Judge.
Okay, state, any objection to that?
No objection, Your Honor.
Okay, so Mr. Muldoon, you'll appear in front of Judge Stone on April 17th at 9 o'clock, okay?
Thank you.
Thank you, Mr. Muldoon. Thank you, Mr. Barnes. Merry
Okay.
Christmas, sir.
Thank you, Your Honor. Merry Christmas to you, sir.
Thank you.
Ricardo Rowe is next, Mr. Cox.
And I've got the jail coming on.
Yes, sir, for the 1:30.
Good, thank you. Jail will take your case right after this case.
Yes, sir.
Yes, sir.
Judge, this is Mr. Ricari Rowe, 24 CF 804. This morning, the violation will be dismissed and my client will be reinstated back on probation.
To the state, is that accurate?
That's correct. I want to make sure he reports. He didn't make it last time, so he's not reported to probation yet, so he's at the very beginning. The state is satisfied with the way the case that another case pending, the way they're resolving that, so we would like to just let him start on the probation. So we
Okay.
can dismiss the VOP and basically
Okay.
enforce the original plea agreement.
Mr. Rowe, no downside to you for that, so your violation of probation is dismissed. Your original plea, your original sentence is reinstated with all the terms and conditions. If you're released before 5 o'clock today, you need to report to probation today. If it's after that, then report tomorrow morning at 8 o'clock, okay? Do you still live in Fort Walton? Where do you live?
Destin.
In Destin, okay. So he needs to report to the Fort Walton office?
Yes, sir.
Okay. Thank you, sir.
Yes, sir.
Judge, this is Marvin Lucky on the 130 docket.
Okay, thank you. Mr. Kleins?
Your Honor, this is Mr. Lucky. Hey, Marvin, look, man, I have been trying to get an offer from the state. They have not been in a position to offer anything at this point. You have been charged with 1 count of grand theft. We will enter a not guilty plea, waive the formal reading. This is currently set on the March docket. I would ask that the court put this on the January 13th docket. I do expect that the state will have some sort of a plea offer by that point.
Okay.
And I would like to turn it over to Mr. Gomez so he can inform the jail.
Yeah, that's correct. I just want the jail to know, because they had been contacting Mr. Kleins. This isn't anything that Mr. Kleins is holding up. It's on our end. We want to make sure that there's a restitution amount that is owed, and so we're trying the best way to try to figure out how we can get that while not extending the negotiation. So we'll work with Mr. Kleins and the victim to try to get some sort of a resolution on that January 13th day, Your Honor.
Okay. So, Mr. Lucky, you'll appear in front of Judge Stone if you're in the Okaloosa County Jail on January 15th. They'll transport you to appear in front of him on January 15th. If you get out of jail before January 13th, then you need to appear on January 13th at 9 o'clock. So stay in touch with Mr. Kleins, okay?
He's currently under a DOC sentence, Your Honor. So
Okay.
he'll be in January 15th.
So you'll be in front of Judge Stone on January 15th. Okay?
Yes, sir.
Thank you, sir.
And Marvin, I'll come see you the week before your court date, okay?
Yes, sir. Thank you very much, sir.
Thank you. Thank you, jail.
Yes, sir. Thank you.
Merry Christmas, y'all.
Merry Christmas.
Thank you.
Judge, you can recall Quentin Purnell.
Okay. Hello again, Mr. Purnell. Good. Yes, sir.
Judge, thank you. This is 23 CF 2186. Behind the scenes, I spoke with Mr. Gomez, and we are stipulating to that 14.7-month DOC sentence, as my client has served that time already. I also reached out to Haven House, so I'm requesting still that my client be held at the Okaloosa County Jail. But I have been informed that potentially he could get picked up today. If not today, it will be Monday at 9 a.m.
Excellent. Mr. Purnell, that's good. I hate when someone has to languish in the jail, you know, for a bed to become available. So, Madam Clerk, if you'll put in the minutes that the state stipulates that Mr. Purnell has served 14.7 months, and therefore he'll be held in the Okaloosa County Jail until Haven House comes and picks him up.
Thank you, Judge.
Good. Thank you, sir.
You have a Merry Christmas.
You too. Thank you. Good
Thank you,
job,
Judge.
Mr. Koch.
Thank you.
Thank you.
Next is Johnny Santiago Rodriguez.
Morning, sir.
Judge, if I may, just a brief moment.
Yes, sir.
Okay. And I'm going to read the terms just like the plea form. Thank you, Judge.
Yes, sir.
Yes, Your Honor. This is Mr. Johnny Santiago Jr., 24 CF 1478. Counts 1 and counts 2, both will be the lesser included offense of assault. That's Florida State Statute 784, 2.011 subsection 1, both second-degree misdemeanors. Counts 1 and counts 2, adjudication of guilt, credit for time served, court costs, and 150 in defense costs, Your Honor. If I may approach.
Yes, sir. Thank you, sir. Mr. Santiago, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
I do accept your plea. You're adjudicated guilty to the lesser included offenses. You're sentenced to credit for time served. You'll need to pay the court cost, $150 public defender's fee. How long will you need to pay that amount of money?
2-3 months.
Okay, let's do 3 months. Is that enough?
Yes, sir.
Okay, so if you fail to pay it within 3 months, then it'll go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, sir. Merry Christmas.
Merry Christmas. Thank you.
Thank you, sir. Hello, Mr. Shear.
Your Honor, may I have a brief
Yes, sir.
To the judge. Thank you, Your Honor. This is Mr. Ricky Shear in 24 CF 1460. Today, counts 1 and counts 2 will be null prost. Count 3, the remaining misdemeanor charged, will be adjudication of guilt, credit for time served, court costs, and 150 in defense costs. If I may approach with the plea form.
Yes, sir. Thank you. Mr. Shear, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Shear, did you read the plea agreement?
Yes, I did.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, I did.
Mr. Shear, I do accept your plea. You're adjudicated guilty on count 3. Counts 1 and 2 are dismissed. You're sentenced to credit for time served. You'll need to pay the court costs, $150 public defender's fee. How long will you need to pay those amounts?
I've been in here for 6 months now, so at least 90 days.
Okay. Do you want 6 months?
Yes, sir.
Okay, you got it. If you fail to pay it within 6 months, then it'll go to a civil lien or judgment. Okay? Thank you, sir.
Sir, okay, you're welcome.
Hello, Mr. Smith. Good morning.
Your Honor, this is Mr. Smith in 24 CF 111, 24 CF 1640. We've been working out a counteroffer, Your Honor. Unfortunately, it's not set in stone as of right now. So if we can keep my client on that January 16th pretrial date. But, of course, next week there is a court date available if we firm up an offer with the state attorney's office. And Judge Brown is allowing us to set people on that date. So if we do reach an agreement, hopefully we can bring them in next week.
Mr. Smith, I hope to see you a week from today. If I don't and you're still in the jail, you'll appear in front of Judge Stone on January 15th, okay?
Thank you.
Thank you, sir.
1 second. Okay, that's all. Thank you, Judge.
Yes, sir. Mr. LaPella, are you ready?
I still need to talk to Mr. Snell.
Okay.
Yeah. Well, Judge, I don't know if the court wants to take it. So we're about to call 2 cases that are going to be legal hearings. There's no witnesses or anything. I know one of those hearings, I know the state doesn't want that to be.
Well, I spoke, we're gonna change it, he's gonna sit outside.
Okay. I don't know if the court wants to take a recess. I know the court typically likes to take a recess, but I would imagine.
Why don't we take a 10-minute recess and then we'll come back and finish up in the morning? Thank you.
All right, please.
I don't really care.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base in Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to deployed men or women, to APOs, FPOs, I would suggest getting in the mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy Christmas as well. In other parts of the U.S., you can also refer to the post office's website for those particular locations. Shipping outside the U.S., give it time. So again, sooner is better. On behalf of your Crestview Eglin Air Force Base and Fort Walton UPS stores, we want to wish each and every one of you a very Merry Christmas and a prosperous New Year's. If you need any help, come into any of our stores and we'd be glad to help you. All right, see you next year.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those. Hi, I'm attorney Michael Gilbert, and from all of us here at Warrior Law, we wish you and yours a safe and happy holidays.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
You're calling the docket?
Richard Williams next with Mr. McKinney.
Thank you. Filibuster.
Mr. Williams will be out shortly in 23 CF 1259.
It's me. Yes, we got it at 4:20 yesterday. We got it at 4:20 yesterday. Because
They were moving around some people, so it was just.
Okay.
We need a Christmas attitude adjustment right now. All right? Man, peppermint milkshake at Chick-fil-A.
Because we play him again next week.
I'm with you. I do strawberry.
Free, too, I say. I said no. Yeah, I meant free.
stuck in the past, dude.
He's got this quarterback at Liberty and twice at Auburn with two different teams. Good for him, man. That dude raises the level of every team he plays on. Poetic justice if he transfers all
I lose my mind.
Oh, can you imagine somebody on God and Florida State? With that read option, you know he can run. That boy can run.
Yeah.
And throw it on the back.
Then it's entertaining. Legalized gambling.
I'm just going to try and get that off. That guy was clean out willing to, right?
You do? You got to open for them to close it. But it sounds like it's moving somehow in your direction.
Wait, we're not pointing fingers, just open it.
Dang, right.
Just order coming in.
I got you.
Dude, we're all like pasty white and cold. Yeah. We come in with a tank.
I got something that says red category from the clerk's office. Have you ever seen that before? Either. Correspondence to the court. And it's incarcerated in a different city. But red category.
Did you, sorry. That's okay.
Good morning.
Did you have the chance to read this all the way through? Do you have any questions? Okay. Yes, sir. Judge, Mr. Williams at this time is going to be admitting to the violation of probation in 23 CF 1259. The agreement that's been reached with the state is for an adjudication of guilt. He's previously been adjudicated in this case. 6 months in the Okaloosa County Jail with credit for time served. That will revoke and terminate his probation. Mr. Williams is going to ask for a period of time after his release to pay off the financials. May I approach the plea agreement?
Yes, sir. Thank you. Mr. Williams, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. Williams, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Always.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement? Mr. Williams, I do accept your plea. You're adjudicated guilty. You're sentenced to 6 months in the Okaloosa County Jail with credit for all time served. Your current supervision is revoked and terminated. You'll need to pay the $100 cost of prosecution, $150 public defender's fee. How long will you need to pay those financials?
6 months.
Yes, sir. You got it. Thank you, sir. Good luck to you, Mr. Williams.
Next we have Marcus Lane, who was on the 2:30 docket.
Okay, thank you.
Your Honor, this is Mr. Lane. He's before the court this morning on a motion to suppress the search warrant affidavit, or actually technically to suppress what was found in the location. I did talk with Mr. Gomez. I do have Defense Exhibit A, which is an unmarked copy of that affidavit. I wanted to state it.
No objection, Your Honor.
May I?
Okay. Yes, sir.
I just want to make sure this was formally in the record.
Thank you. Yes, sir. So Defendant's Exhibit A is admitted into evidence.
So, Your Honor, we are here on an argument basically that the probable cause in that search warrant affidavit is insufficient to justify the issuance of it. I want to be clear on the standard of review here. At this point, what this court needs to be doing is conducting, it's not a de novo review. The court is to afford great deference to the issuing magistrate. Actually, one of the cases I was reading for this argument, I don't know how you would do this, but a trial judge struck his own search warrant that he had authorized, and the appellate court said he didn't give enough deference to himself, which I didn't understand that. But so the court does have to grant great deference to Judge Gontaric's issuance of the search warrant, decision to issue the search warrant, I should say. I'm sorry. And this actually comes from a case that was provided by Mr. Gomez this morning. This is the State versus Carino 35 Southern 3rd 125 case, which is a 3rd District decision. In that decision, in part, it says, when reviewing the issuance of a warrant based on probable cause affidavit, the trial court does not conduct a de novo determination of whether there was probable cause. Instead, the trial court determines only whether substantial evidence supported the magistrate's determination that probable cause existed. I think I've laid out the arguments for Mr. Lane as well as I could in the written motion. I'm not going to go through the motion and make those point by point. I did want to talk about the cases, though, that I did mention in this motion, and I'll do them in order, Your Honor. The first one is State versus Jones. The Jones decision is from the 2nd District, and the Jones decision involved a situation where there was a confidential informant and 2 controlled buys within a period of 11 days from the subject residence that was searched in that case. Mr. Jones obviously appealed the court's determination that the probable cause was sufficient. If the court goes back and reads the Jones case closely, which I did all of this yesterday again, there's a lot of similarities and differences between Jones and Mr. Lane's case. The primary difference is that in Mr. Lane's case, there is no confidential informant. There is no control buy at any point from this particular residence that was searched. Give me a second. So generally speaking, if we're attacking a search warrant, or affidavit, I should say, the court or the affidavit must satisfy 2 elements. A particular person has committed the crime, that would be Mr. Lane. That's the commission element, and that the evidence relevant to the probable criminality is likely located at the place to be searched, which is the nexus element. Every single case that the Jones opinion talks about, that's State versus Gisecki, Clark versus State, every one of these cases that decision analyzes in detail involves a confidential informant and a controlled buy. Every single one of those. In the Sanchez case, the Sanchez case actually kind of has a lot of similarities. I confused Sanchez with Jones. The Sanchez case has a lot of similarities with Mr. Lane's case here, leading up to the issuance of the search warrant. It involved an anonymous tip through Crime Stoppers that was received by law enforcement that a white female was selling methamphetamine from a particular residence. It actually included the license plate number of the vehicle description. That plate was registered to the defendant. And the detective also observed a vehicle parked in the driveway of that particular car parked in the driveway of the residence about 11 days before he applied for the warrant. They did a criminal history check. The detective in that affidavit in the Sanchez case goes into prior criminal record, just like Investigator Jennings did here. As a matter of fact, this is a 2011, all this was happening in 2011, and the detective in that affidavit talks about a prior conviction from 2003. The appellate court kind of said, yeah, that doesn't mean anything. But it just was weird as I was reading this. I was like, oh, this affidavit also talks about prior criminal record, and this affidavit also talks about prior alleged instances of criminal conduct and confirmed instances of criminal conduct. There was a traffic stop in the Sanchez case. The driver was identified in that stop, and she was actually found with methamphetamine. But she was also found with cameras, and she told the law enforcement officers who conducted that traffic stop, I went to the residence to sell cameras, and then they found cameras. So I think they kind of chalked it up to, well, that probably sounds about right. I mean, she's not giving us a story that, I mean, she has cameras with her. Like, it seems that seems pretty consistent with what she was doing. Again, like this affidavit that is before the court now in Sanchez, the detective in Sanchez conducted personal surveillance on that residence, and he saw somebody approach the front door, which is what Deputy Jennings did here. Or, I'm sorry, Investigator Jennings. It just seemed like it was weird going through the Sanchez case, especially the background of it and how much it tracked Mr. Lane's, kind of what was in the affidavit in Mr. Lane's case. The detective in Sanchez observed no hand-to-hand sales, no high traffic patterns. This is the detective's personal observations, commonly associated with drug sales. Now this particular situation, that detective did not do any trash pulls. Investigator Jennings did, but that detective also did not use any confidential information as part of the investigation. And interestingly, the detective in the Sanchez case actually testified at this hearing, which these type of situations involve just the four corners of the affidavit. I don't really understand how the detective was testifying, but it is what it is. The Sanchez court said that although the criminal history of a suspect can be a factor when determining whether probable cause exists, it does not show current drug sales were taking place at the residence when there was otherwise no such evidence. And even the tip here failed to state when any drug sales had occurred. When the court looks at the search warrant affidavit, the two Crime Stopper tips don't allege any particular dates or times of when these transactions were supposedly occurring. And that's important, and that's one of the reasons why Florida courts will generally not just invalidate a warrant for staleness just because, but there is case law, and it's pretty consistent that the older it gets, the older the information gets in the affidavit, the less it tends to support an actual search. So that's why the timing of when these tips were supposedly claiming Mr. Lane was selling drugs out of this house are important, and we don't even know what they were. Judge Gonteric didn't know what they were when he was presented the affidavit. I don't know if he asked any questions of the investigator presenting the affidavit, but there's just no information in the affidavit of when these alleged anonymous tips were, when these anonymous tips were alleging that sales were occurring from this residence. And this is a residence that Mr. Lane didn't even move into until January. And the first tip was received in December. And the Sanchez court ruled that based on the totality of the circumstances, the affidavit did not establish a fair probability the evidence of methamphetamine sales would be located at the residence. A significant focus of the affidavit here was on old criminal history, and nothing showed an actual drug sale at the residence to corroborate the anonymous tip that did not specify a time frame. Thus, we conclude that an objectively reasonable officer would have known that the affidavit was insufficient to establish probable cause for the search. Moving on to Clark, Your Honor. Sanchez is kind of a longer opinion. Clark's pretty straightforward. Clark stands for the proposition that a single controlled buy at any residence will establish a sufficient basis to issue a probable cause, or I'm sorry, to issue a warrant. There's a language, Clark conceded that circumstances showing a completed controlled buy would sufficiently have established the informant's reliability so as to validate the warrant. So the way I took that is, if there's a search warrant affidavit that alleges a controlled buy coming from any residence, at least that language seems to suggest that's automatically going to corroborate it. So if a controlled buy is involved, I think the argument becomes much harder for a defense to say there's not sufficient probable cause, at least based on that language from Clark. But Clark kind of ends with, the issuing magistrate must simply have a substantial basis for concluding that the search would uncover evidence of wrongdoing. And that's kind of where we're going with this, Your Honor. Some of the information that was in this affidavit, in my opinion, completely should open the court's eyes to, why is this in here? For example, Investigator Jennings claims that he conducted personal surveillance of this residence. He saw one individual approach the door. And to his credit, Investigator Jennings says, look, I wasn't in a position to see him actually get to the front door. I don't know if he went in. But he saw one individual approach the door and then turn around and leave within a short period of time. He doesn't know if he went inside the residence. He doesn't know how, if he was, how long he was in there or who he talked to. The guy could have gone up to the front door and knocked and just left, you know? I mean, people aren't home sometimes. And that's the only time that Investigator Jennings ever witnessed any personal foot traffic in here. Everything else is, there's anonymous tips about, well, there's a lot of foot traffic. Well, if there's a lot of foot traffic, then how come that's the only time Investigator Jennings happened to see anybody approach the door? And not only that, he just approached the door and then left. Investigator Jennings put in there that the one time he actually conducted a trash pull, actually 3 investigators conducted a trash pull, they found one piece of plastic that was contaminated with food waste. It couldn't even be tested. The idea that an investigator has to put the fact that he recovered a piece of trash from an exterior trash can that has covered with food waste, I mean, that has no evidentiary value of anything. I mean, I would imagine that most exterior trash cans associated with people where people are living are going to have pieces of plastic covered in food waste. I mean, that's how things get thrown away. I mean, that to me, the fact that that's even in there is highly indicative of how less information law enforcement really had. I mean, they could have easily sat on this house and watched it. They could have done any number of things and gotten the warrant based on their own observations. If this was really a situation where Mr. Lane was selling drugs out of that house, the way Investigator Jennings makes it sound in that affidavit, it shouldn't have taken more than a couple of personal sessions of surveillance for law enforcement to say, I've seen 20 people go up, or I've seen this, or I've seen that. And there's nothing in there. Investigator Jennings is relying on unnamed Fort Walton Beach police officers to this day who have not been listed as witnesses in this case, saying that they allegedly stopped a car that had THC wax in it, that whoever the unnamed driver was blamed Mr. Lane for selling him the drugs. None of that has been fleshed out in depositions. None of that has been even officially noticed by the state saying, hey, this is who these officers were. To this day, I don't even know who those Fort Walton Beach police officers were. So our argument, Your Honor, is laid out as well as I could put it in writing. We don't believe that there's probable cause sufficient here to establish that the warrant should have ever been issued, and we're asking the court to suppress everything that was recovered from 136 Rainbow Drive.
Thank you. To the state.
Thank you, Judge. I kind of, just because it was just mentioned in regards to not having any of the officers listed or anything like that in terms of getting depositions, when this court is reviewing the arguments and this information here, it's whether or not the magistrate at the time that they were reviewing this document believed or there was substantial evidence that probable cause existed. So I just kind of want to make sure that that's understood, that the depositions, whether or not witnesses have been made available or listed, that's almost irrelevant to the analysis of whether or not substantial evidence existed at the time the reviewing magistrate was reviewing the warrant, and whether or not he had substantial evidence that probable cause existed. I first wanted to kind of go through the cases that the defense pointed out, and the first one I really want to talk about is Sanchez. A lot of the analysis in the court in Sanchez, and like Mr. Klein stated, it was a little weird reading it because generally when you're talking about a motion to suppress with a search warrant, you're limited to what was written in that search warrant. And in that case, you have the officer who wrote the search warrant actually get up and testify. And during his testimony, the court finds out very interesting, pertinent information that somewhat contradicts what was written in the affidavit, and the court pointed that out. Namely, for example, on the July 18th, 2011, Wells, who had been arrested for possession of meth and drug paraphernalia after leaving Sanchez's residence, she had told law enforcement that she was there to sell digital cameras. Law enforcement conveniently left out of that affidavit that there was actually digital cameras inside of the car when they were searching it. That's something that the court found and noted in their analysis. Another instance, the detective actually goes, when he was on the stand and he's testifying, he testifies that he did not see anyone from the residence actually make contact with anybody in the vehicle in reference to an August 26, 2011 date with a PT Cruiser pulling into the driveway. So there was testimony from the officer that the court found almost invalidated or at least brought into question a lot of the information that was in the affidavit, and that is quite different from the scenario that we have here. In Jones, they have the two controlled buys where they sell the narcotics, they set up a controlled buy where the narcotics are sold to their confidential informant. And with regard to that, I think I kind of understand where the defense is going with this in the sense of, this is an example of something that the court found to have been enough to grant a search warrant. And while I don't disagree with that, I also want to posit that a controlled buy is not required in order for a magistrate to issue a search warrant. I also wanted to point out in Jones, just because there was some language that I thought was important just in terms of we're talking about element 2 of the nexus of inside the residence. The court in that said that we also conclude that the fact that Ms. Jones stepped outside the residence and sold the drugs to the CI does not lessen the probability that the contraband would be found in the residence. So that is talking about the nexus of why or how a magistrate would believe there would be a substantial likelihood of finding that contraband inside the residence. I also wanted to point out that the court in Jones addressed the issue of staleness in the last kind of subsection where it talks about, generally speaking, if the issuance of the warrant occurs within 30 days of the observation of the evidence establishing probable cause, then it's not going to be stale. And so now I kind of want to turn to the scenario that we have with us in our affidavit. A Crime Stoppers tip first comes in, and it says in paragraph 1 of the affidavit, in December of 2023. And it actually lists Marcus Lane by name and claims that he's selling large quantities of marijuana and cocaine within Fort Walton Beach. And then goes on to actually say the drugs are kept and sold from Lane's vehicle. The information regarding the criminal history, I think I definitely agree with Mr. Klein, is that in the cases that he cited, they talk about criminal history isn't going to have that much of an effect. The state's argument would be, particularly with the March 2023 bit in the affidavit, that is there to show that Lane consistently keeps narcotics in his house to sell out of his residence, which is why it's another kind of way to establish the nexus that there was a substantial likelihood or a substantial evidence that the narcotics would be found in the premises to be searched. Then you start getting the actual tips, and it's not one tip, it's multiple tips. The first one comes in December 26th, and I think this one is important because it specifically identifies Mr. Lane, and it specifically identifies the fact that Mr. Lane is selling THC wax, and I want to highlight that THC wax, vape and flour, as well as cocaine. Further, the tipster explained that Lane receives narcotics in the mail and distributes approximately 100 carts and 2 to 4 ounces of cocaine per week. That's not vague information, that's relatively detailed information with particularity to the THC wax, because that's going to come into play a little bit in my argument. We also see that on January 5th, They receive another Emerald Coast Crime Stoppers tip in reference to, again, the name Lane distributing narcotics at the premises to be searched. The tipster stated they have observed money and baggies being passed at the premises to be searched, and that there was short-term traffic at the premises to be searched where people stayed for approximately 2 minutes. I want to point out that time there because when we do see the one time that Investigator Jennings personally surveilled the area himself, he makes a comment that it's approximately 2 minutes later. So it's this consistency of people coming in, doing whatever they're doing at the house, and then leaving 2 minutes later. It's a consistent, and that is something that corroborates these tips that clearly somebody is seeing something because they're saying this 2 minute time frame, and here we go, we're seeing 2 minutes. On January 10th, at the premises to be searched, this is during a surveillance, and admittedly it's Fort Walton Beach Police Department. They see a vehicle arrive and departed shortly after making contact with Lane in front of the residence. They conduct a traffic stop on the vehicle after leaving the residence, and during that probable cause search, they find THC wax. That's important because it directly substantiates the Crime Stoppers tip from December 26th of 2023. And then during that interview of the driver advises them that he just purchased the THC wax from Lane at the premises to be searched just prior to the stop. This is very different than in the, I believe it was the Sanchez case, where they actually asked the individual driving, where they pulled her over, about the narcotics they found. And she said, I actually got this from the night before, never mentions the defendant in that case, and that was a very small amount of residue. This is not, that's very different than the situation we have here, which is they see him leave, they see the individual leave the premises to be searched, they search the vehicle, and they find THC wax, which is a contraband that was specifically defined in the Crime Stoppers tip on December 26th of 2023. Then we see on January 22nd of 2024, this is where Investigator Jennings conducted his own personal surveillance. He sees this short-term foot traffic, and much to Investigator Jennings, I applaud him for he's very honest in his search warrant, saying, hey, I didn't see him actually make contact at the front door, but I know that he was there for approximately 2 minutes, and then we see him walking back to the truck and then departing. Then on January 22nd, that same day, they receive a Crime Stoppers tip in reference to more short-term traffic occurring at the premises to be searched. The tipster in that provided specific vehicle information of someone who would arrive at the residence and only stay for approximately 2 minutes and then leave, and gave the tip that this occurred on multiple days. Then on January 22nd, 2024, a second tip that day references an unusual amount of traffic at, and it actually, they say 134 Rainbow Drive. We're talking about 136 Rainbow Drive, and in the affidavit, the Investigator Jennings specifically talks about, based on the information that was provided with respect to the red Ford F-150, that car being belonging to Mr. Lane, that car was actually in front of 136. And so they discussed that the tipster states the vehicles arrive and make short-term contact with the male tenant in the driveway, or the person will go to the front door. The person will only be at the residence for approximately 2 minutes, and then they will leave. On January 13th, so we're kind of backing up, we have the affiant and other investigators, they do a trash pool. And in that trash pool, they find, and I think this is the most important part, a plastic baggie which had the corner torn off. And I'm going to talk about that in a second whenever I have a couple of cases that I want to talk about. But they have a plastic baggie with the corner torn off. And in the affidavit, the affiant specifically talks about how narcotics are often sold in the torn off corners of plastic sandwich baggies. Further, it is common for the drug purchaser to have the torn off corner of the baggie, and then the distributor to have the remaining top corner of the baggie as found in the trash can. And they couldn't test it. I think the reason why they couldn't test it is because of the food waste, and it contaminated the bag, so they weren't going to get any sort of information from that. This is coupled with the fact that they also had a trash pool with the Fort Walton Beach Police Department where they find a plastic baggie with residue field tested positive for fentanyl. I think this goes back to the tips talking about they have observed money in baggies being passed at the residence to be searched. So while I understand that these are anonymous tips, the surveillance, the trash pools, the traffic stop that occurred after watching the defendant leave the residence, not the defendant, I'm sorry, the individual leave the residence, and that individual saying that he purchased narcotics from specific narcotics that were listed in a tip from the defendant at the premises to be searched, that's just corroborating evidence of all of these tips. And so it's not just that these anonymous tips are occurring and there's no corroboration of them. These anonymous tips are occurring. They're occurring quite frequently. They're more specific in talking about the specific vehicles that are appearing. They're specific in the time that these vehicles are staying. That time is then corroborated by personal surveillance of the affiant. And then they're also talking about specific contraband. They're talking about the method in which these transactions are occurring by handing baggies and money back and forth. And then we're finding baggies in not one but two trash pools, one of them being a presumptive positive for cocaine, the other having a corner torn off in which the affiant writes or states that is common for drug sellers or drug traffickers to have that portion of. I wanted to talk about, let's see, two cases, and I provided Mr. Kleins with both of these cases, Your Honor. One of them is State versus Carbonell, 816 Southern 2nd, 1169, and it is a Florida 4th DCA case.
Thank you.
Then the next case is State versus Carreno, 35 Southern 3rd, 125. This is the 3rd DCA case from 2010.
Thank you.
So I wanted to talk about Carreno, and the Carreno mainly is going to go towards the corroboration of an anonymous tip by an incident that occurs later on in the day. In that case, detectives in the Miami-Dade Police Department received an anonymous tip that the defendant's house was being used to grow marijuana and that the owner would be cropping the harvest that day. They then set up surveillance on the house, and later on they stop a truck. They see a truck pull into the property, and they note that the truck had nothing in the back of it. When the truck leaves the property a short time after, it now has these garbage bags that are in the back. So they conduct a traffic stop. During the traffic stop, a law enforcement officer observes the odor of marijuana emanating from the black bags in the back of the truck. They search the black bags, and they find essentially evidence of harvesting marijuana. It's like roots from marijuana plants, stems, things of that nature. The court in Carreno says here, however, the anonymous caller reported that the defendant would be harvesting the crop that day. When police searched the garbage bags, they found clippings, leaves, and a root system, evidence that substantiated the caller's claim. They found that that anonymous tip, coupled with substantiating that anonymous tip, was enough for a magistrate to find that the probable cause existed, and they even went so far as to talk about finding that it was grown inside the defendant's home. We have multiple anonymous tips, and we have multiple instances of corroboration, specifically with that traffic stop that occurs where the individual who was stopped had THC wax, a specific substance that was identified in a tip, and directly implicated the defendant as the one selling him that THC wax at the premises to be searched. So that was the Carreno case. In Carbonell, Your Honor, that is a case in which they talk about a trash pool, and the law enforcement officer did a trash pool, and it's a little bit, I had to kind of read this a few times. They did a trash pool at what they're going to call the Somoza residence, and this was about a year prior to this incident. They then start setting up, and during that trash pool, they saw baggies with cut corners containing cocaine. Their surveillance was then set up at the defendant's house, in this case, Carbonell. The law enforcement officers observed themselves personally a lot of short-term foot traffic. They saw individuals smoking what appeared to be marijuana on the porch. They observed individuals leaving with what appeared to be plastic baggies of cocaine. A second trash pull was conducted, and they found marijuana stems and several baggies with corners cut out in a way similar to the narcotics transactions and bags found at the Somoza's residence. The law enforcement officer in that actually tested or wrote in his affidavit that based on his experience with multiple drug transactions, that in a very similar way, the cut corners is indicative of narcotic sales. And then at the end of that, they stated, and I think this is important, we conclude that they actually had a confidential informant go in, talk about the narcotics transactions, even though they hadn't personally bought, and then they sent the CI into the residence where they observed a small packet of cocaine inside the residence. The court in Carbonell stated, we conclude that even without the confidential informant's information, the affidavit contained other information sufficient to establish probable cause. So without that confidential informant, you're looking at substantial short-term foot traffic entering and leaving the appellee's residence during the month prior to the issuance, observing people smoking what appeared to be marijuana on the front porch, and others leaving the residence with baggies of what appeared to be cocaine. And then 2 days before the issuance of the warrant, a single trash pull which revealed the presence of marijuana and bags cut similar to the law enforcement officers' observations in other drug investigations. Your Honor, simply put, we have all of those things. We have multiple tips of information with specific information talking about the vehicles that are showing up, the time that they're staying. In one specific tip, we are talking about the specific narcotic. In this scenario, I want to point out the THC wax that's being sold. We then have a traffic stop that is conducted as a byproduct of surveillance. And during that traffic stop, the driver of the vehicle admits that he purchased the narcotics from Mr. Lane, and that narcotic was THC wax at the premises to be searched. We have the plastic baggies that are cut in a way that is indicative of narcotics transactions and sales. We have a plastic baggie that was found in a trash pool with a presumptive positive result for cocaine. Given all of this, Your Honor, it does seem clear in reading the case law that a magistrate in reviewing this had substantial evidence that the probable cause existed and that contraband and criminality would be found inside the premises to be searched, Your Honor. And that's why we're requesting that this motion to suppress be denied.
Thank you. Mr. Gines, final.
Your Honor, the Carino case is highly distinguishable from the situation here. The Carino case, they got an anonymous tip that somebody was going to be harvesting marijuana that day, and then law enforcement personally witnessed a truck pull into that residence and leave with trash bags, and that truck then ran a stop sign and was pulled over. And Mr. Gomez is correct. Officers smelled the odor of marijuana, and then they discovered in those bags evidence that marijuana had just been harvested. Specifically, the ruling in Carino talks about root systems being found in those bags. So the fact that Mr. Carino even filed a motion to suppress is kind of, it's impressive to me. I mean, the guy got caught cold-handed. The Carbonell case is also highly distinguishable in that there was multiple significant facts personally observed by law enforcement. For example, law enforcement personally witnessed a large volume of short-stay traffic. Law enforcement personally witnessed people leaving that house with bags of clear white powder in their hand. Law enforcement did conduct a trash pull, and they found a marijuana stem in several baggies. The affidavit in this case found one bag that the defense is going to say is a piece of trash, a common piece of trash. I don't care how it wound up in that. I don't really care that law enforcement thinks that every torn bag in this county is indicative of drug sales. That's ridiculous. It's patently ridiculous. The other trash pull field tested positive suspected for fentanyl, which is not what this search warrant was asking to search for. So this court has one trash pull with a positive field test. It has one date that Investigator Jennings witnessed one person walk up to that house and turn around and leave, not knowing whether they even made contact with anybody inside. It has one traffic stop. It's highly distinguishable from what exactly was going on in Carbonell. And I would point out that the reason Carbonell says we conclude that even without the confidential informant's information, because the entire basis of Carbonell's motion was that the affidavit was insufficient because the probable cause didn't exist because the information was based on a confidential informant whose reliability was not personally known to the law enforcement officer asking for the warrant. So that's a totally different procedural issue here. The argument is basically that Investigator Jennings rushed this affidavit to the court trying to get a permission to go into this house, not having personally observed much of anything at all over the span of a couple of weeks. When, I mean, if he did take the stand, I'm sure he would agree, yes, we've had people under investigation for far longer than 3 weeks. And not only that, and I want to point this out, the probable cause affidavit itself, in part, at the very beginning, before it even gets into paragraph 1 or 2 or 3, says, since this affidavit is for a limited person, your affiant has not included each and every fact known about this investigation. That's a problem. And it's a problem in a situation like this where we can only look at the four corners of the affidavit. Well, if there's other information that exists, why is it not in the affidavit? Period. And so that's concerning to see law enforcement saying, oh, there's other information, we don't think you need to know. Well, why not? I mean, if all we have is this, and this is all the court can look at, then the court is not getting a full picture of what the law enforcement knows. So, those are arguments, Your Honor.
Thank you. Mr. Lane, I did read through the motion to suppress, highlighted different things in there. I asked for the affidavit because I didn't have that for the search warrant. I went through that yesterday, I believe. Highlighted different things in there. I didn't put much emphasis on, and maybe because I read Mr. Klein's motion first, but I didn't put a lot of emphasis on the anonymous callers, the buyer that wasn't named, didn't give the name, that certainly made an impression on the court. What I looked at were the positive facts that were alleged in the affidavit. What makes it easier for the court today is the burden of proof. If it wasn't for that, it would be a tougher decision for the court. But with the deference to Judge Gonteric and the degree of, was there substantial evidence to support that determination of probable cause, I do find from the totality, and that's where those anonymous tips come in and do help some, but respectfully, your motion to suppress is denied.
Your Honor, if we could leave Mr. Lane on the January 13th docket.
Okay. Mr. Lane, you'll appear in front of Judge Stone. If you're incarcerated, it'll be on January 15th. Okay? Thank you.
Next is David McLeod, also on the 230 docket.
Thank you.
Your Honor, this is Mr. McLeod. He's before the court on a Rule 3.190B motion to dismiss. I just want to ask Mr. McLeod one question under oath.
Yes, sir. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Mr. McLeod, when did you become aware of the decision in Allman versus State?
Approximately February to March of 2022.
I have no further questions.
Okay. Any questions from the state?
No, Judge.
Okay. Yes, sir, Mr. Collins.
Your Honor, one of the reasons why this has taken so long to get to this position is when I first met with Mr. McLeod, he started talking to me about filing a motion to dismiss or entrapment of something that had happened obviously 9, 10 years ago. I had zero idea that Mr. McLeod had filed so many post-conviction pro se motions at that point. And so I did go through and I tried to walk the court through the procedural issues here because I was kind of learning as I went. I didn't even know any of this was happening. And the reason why I asked Mr. McLeod when he knew about this Allman decision is because Mr. McLeod certainly, and I will concede, definitely, I saw the state's response yesterday, that Mr. McLeod has essentially been making a version of this argument to the courts in a post-conviction kind of a footing since about 2017, 2018. He didn't know about this Allman decision until about 2022, and I didn't know about this Allman decision until I met with him and he gave me the site. I mean, this is a case that he found that I have never even heard of in 10 plus years of practice. And I think one of the problems for Mr. McLeod is, number one, he didn't know about this decision until he'd already argued this twice to the court under different procedural footings. And number two, and I don't mean to denigrate Mr. McLeod in any way, shape, or form, but he's not a licensed attorney. And I have a feeling a lot of times a lot of pro se clients think that real attorneys file real lengthy stuff all the time, and that's just not the case. This is a very simple argument that he's trying to posit to the court today. And that's the argument that law enforcement cannot violate the explicit terms of a Florida criminal statute just to enforce the law. That's what his argument really boils down to. And that's what Allman talks about, and that's all Allman talks about. Allman, for the record, is 642 Southern 2nd, 1203. And it's a real short opinion. But what happened in Allman is very disturbing, but the Broward County Sheriff's Office in this Allman decision, back in the early 90s, had decided we're going to start cooking our own crack cocaine, and we're going to put it on the streets in controlled buys so that we can therefore conduct some reverse sting operations. Well, whoever was in charge of that decided that we're going to do this within 1,000 feet of a school, and then they lost control of some of the inventory. So frankly, the Broward County Sheriff's Office put some crack on the street back in the early 90s. And the 4th District said, we're not having it. And the 4th District specifically said, and he's in a similar situation that Mr. Allman was too. The defendant in Allman had entered a plea, had been sentenced to probation, and then had violated probation. And then once the violation was alleged, that's when the defendant in Allman raised a constitutional due process argument that is not time barred, and arguing there is no statutory provision authorizing any law enforcement agency to manufacture their own drugs. And therefore, because there's no legislative authorization for law enforcement to do that, by the terms of the law, the Broward County Sheriff's Office was violating the sale, manufacture, delivery statute back in the early 1990s. And the Allman court actually agreed with him. And even pointed out, it's undisputed that Allman pled guilty to the crime charged. But the 4th District in that Allman decision says, at bar, the illegal police activity of manufacturing crack cocaine leading to Allman's arrest invalidates the arrest, which in turn invalidates Allman's guilty plea. Therefore, even though Allman can be said to have accepted the benefit of his bargain by pleading guilty and accepting probation, since the solicitation charge involved a denial of due process, the original conviction and sentence were illegal. Thus, we reverse with instructions to discharge Allman as to this offense. And the reason why I say this is very simple is because Mr. McLeod's argument turns on the Florida statute 934.215, which I filed a motion asking this court to take judicial notice of earlier this week. This is the unlawful two-way communication device statute. And this statute reads, in full, any person who uses a two-way communications device, including but not limited to a portable two-way wireless communication device, to facilitate or further the commission of any felony offense commits a felony of the third degree, punishable as provided. That's it. There's no law enforcement carve-out exception in this particular statute. Anytime law enforcement is using a two-way communication device to facilitate the commission of a felony, they are violating the statute. And under Allman, Allman makes clear that there is no provision for law enforcement to just violate whatever law they feel like they need to conduct reverse stings. Now, I pointed out some of these cases, Your Honor. The Kelly opinion directly says In other words, the police agencies cannot themselves do an illegal act, albeit their intended goal may be legal and desirable. And as a matter of fact, at least in one of these cases, the court says, look, law enforcement can do reverse sting operations. We're not saying that that's something that shouldn't be happening. But the argument is really that if that's what the legislature wants to authorize law enforcement to do, then they need to amend 934.215 to authorize law enforcement to conduct that type of activity in a reverse sting operation, because as written, it says any person. It doesn't say any person except for sworn law enforcement officers. It just says any person. And so, and it says any person who does this commits a third-degree felony. And so Mr. McLeod's argument is real simple. It's been convoluted beyond belief based in large part on him. But the argument is that because law enforcement was violating the text of 934.215, they then cannot turn around and seek judicial process to obtain a conviction against him, and his actual no contest plea should be invalidated. And in full candor, I'm almost done. He didn't actually plead to the violation of 934.215. He pled to, I believe, traveling. So I want to be clear on that. But, and Allman does, I believe he did plead to delivery of cocaine. But I just wanted to be clear on that.
Okay, thank you. To the state.
Judge, I know we filed it kind of late in the day yesterday. Did you get a copy of our response?
I pulled it up, but I haven't read it.
Okay.
To be honest with you, I haven't done any homework on this because the docket just said VOP evidentiary. So I'm going to take it under advisement. I want to hear what y'all have to say, but I don't want to go back and chew on it and read everything.
Understood.
Yes,
ma'am.
Judge. And I actually think the last court date Mr. Kleins and I had approached, and it wasn't necessarily set for a hearing. It was actually set for him to file his motion.
Right, and this might be my fault. I mean, I apologize. I know we've talked about it every time he's been in court, and so.
Well, I just haven't done my homework, but I will dang sure do it before I rule.
Understood.
Judge, this particular defendant was sentenced back in 2016. He pled to the bench at that point. He did file a motion to vacate or set aside sentence that originally didn't raise any entrapment issues, but he did file an amended motion seeking relief under 3850 in December of 2017, which did address this entrapment issue. He then filed a motion to vacate or correct an illegal sentence in 2018, and again, he claimed law enforcement violated the statute for using a two-way communication device to facilitate the commission of a felony. So that's the same allegation that was made in the December 2017 motion. And while today he testified he hadn't heard of that particular case that Mr. Klein cited, that was still the context of his entrapment issue. It was a two-way communication device, not law enforcement, or entrapping him. In May of 2019, the court, at that time it was the Honorable Judge Stone, denied the defendant's entrapment claim. And the order said that even if the claim had been facially sufficient, the defendant wouldn't have been entitled to relief. Specifically, it said, to the extent the defendant argues he had an objective entrapment defense, his claim is without merit because law enforcement simply presented an opportunity and waited until the defendant contacted them, and the court cited the case Sanger v. State, 200 Southern 3rd, 127, 143. After that was denied, then a motion to dismiss by this defendant was filed pro se in October of 2023. And again, the basis of that motion is the same allegations that he made in the 2017 and the 2018 motions. Claimed law enforcement violated his constitutional rights, and the statute for unlawful use of a two-way communication device didn't provide an exception for law enforcement. The court, I believe it was Your Honor, denied this motion December 14th of 2023, finding he was trying to file second or subsequent motions for post-conviction relief under the guise of a motion to dismiss, and that it fails to satisfy the 3850 subsection H. Then, a year after that denial, Mr. Kleins filed the current motion December 5th, 2024, the same basis as the December 2017, October 2018, and October 2023 motions, but couching the issue again as a motion to dismiss. And they asked that if the court's inclined to deny the motion, it be on the merits that's preserved for review. But we don't believe the defendant has the right to present a motion to dismiss 8 years after the plea on an issue that's been raised numerous times and denied twice by the court in post-conviction proceedings. So we'd ask the court to deny it on the same basis as the order from December 2023, that filing multiple motions for post-conviction relief under the guise of motion to dismiss is inappropriate and that it does not comply with 3850. The motion to dismiss statute they filed under is governed under pre-trial motions. That's the heading. And it explains the time for moving for a motion to dismiss and includes the language that it should be before or at arraignment unless the court grants further time or in its discretion permits the defendant to plead and thereafter file at a time to be set by the court. And unless an objection is based on a fundamental ground, every ground for motion to dismiss that is not presented within the time provided is considered waived. Now, their fundamental ground they're arguing is the constitutional issue, but it's been previously ruled on. And Rule 3190C does outline 4 instances where a court may at any time entertain a motion to dismiss specifically. And that is instances where a defendant has been previously pardoned, placed in jeopardy, or granted immunity from. Obviously, those don't apply in this case. And then if there's been a C4 motion, and the motion Mr. Klein's filed is not a C4, so it doesn't meet the criteria to be entertained at any time under that exception. They are seeking relief after the entry of a plea for an alleged constitutional violation, so the proper basis for relief is governed by 3850. It specifically covers claims where the judgment or sentence imposed was in violation of the Constitution or laws of the United States or Florida. And under 3850B, no other motion shall be filed or considered pursuant to this rule if filed more than 2 years after the judgment and sentence becomes final unless, and there's 3 exceptions. However, all of them are within 2 years of the date of the decision. So he raised these constitutional violations and these subjective and objective entrapment issues in his motion in 2017. And he was aware at the time this claim existed when he pled to the court, because in his motion back in 2017, he said he discussed this with his attorney about possibly filing a motion to dismiss. And in the state's response, as we referenced in to an order to show cause, that we referenced in our motion filed yesterday, there was actually a letter from his attorney at the time before he entered a plea, Mr. Barasset, to the defendant months before he entered a plea to the court, giving him case law and stating that they had discussed an entrapment issue that day. So he was aware at the time that he pled that this claim existed. And under 3850, the time limits for filing additional claims have expired. He pled in 2016.
Let me go back to Barasset. You said that you filed a letter?
No, Judge, I cited to the letter that under whatever the DIN number was, I think in the
your
last
response?
paragraph. Yes.
Okay, good, thank you.
Actually, let me pull that up. There was a letter under DIN number 180 in this court file, filed June 6, 2018, on page 35 from the state.
Thank you.
And as I said, under Rule 3850, all post-conviction motions have to be filed within 2 years. Since he pled in 2016, then all of those motions would have to be filed 2019 at the latest. So the pro se motion dismissed filed in 2023, that was denied, and Mr. Klein's motion filed in 2024 are at least 5 years too late. First, Judge, this was not based on a legal issue or precedent that was not available prior to the court's ruling. And second, 3850J governs rehearing, so even if the prior motion had been timely filed, there must be a motion for rehearing filed within 15 days of date of service of the order, based on the belief the court had overlooked a previously argued issue of fact of law or law not available prior to the court's ruling. So that would have been, again, the end of 2023 had it been timely filed, but it was not. The court, in its order denying the motion to dismiss in 2023, specifically cited Rule 3850H, which provides in part that a court may dismiss a second or subsequent motion if the court finds that it fails to allege new or different grounds for relief and the prior determination was on the merits. So we're asking the court to dismiss what's essentially a second or subsequent motion at this point. It was essentially the same entrapment issues that have been raised in 2017, 2018, and 2023, and they failed to allege any new grounds for relief. And even if the court does find the entrapment motion now being couched as a motion to dismiss is new or different, there isn't good cause for the defendant or his attorney not to have asserted those grounds years ago because they were aware of it at the time he entered his plea. I looked at Mr. Klein's case law, and I would note that they cite Shanks, and Shanks, as quoted, states that this issue may be raised by post-conviction relief. Post-conviction motions, again, are governed by 3850, and the defendant has filed one of those, and it was denied, so he's time barred from raising any additional issues after 2 years unless they meet a specific exception, which he does not. Defense cites Willie, and that holds a fundamental error may be raised for the first time at any point, including a post-conviction proceeding. And again, post-conviction proceedings are under 3850. And that's all good and well, but this is far from the first time this issue has been brought up. Defense also cites Kelly, which is the 4th DCA case. And in that case, law enforcement officers were manufacturing crack during a reverse sting operation. That's very different from law enforcement posting an ad on Craigslist and waiting for a defendant to reach out, which is what happened in this particular case. And as Judge Stone noted in the order denying the previous motion in 2019, no entrapment claims exist here. Defense also cited Allman, but in Allman, the constitutional issue again had never been brought before the court previously. And he's raised this issue in previous motions multiple times and lost. So we don't believe he's entitled to another bite at the apple in this particular case. I would ask the court to deny his motion for the same reason it denied the motion in 2023.
Thank you. Mr. Kleins, finally.
Your Honor, I will absolutely concede that there is a extremely convoluted post-conviction record in this case, and that Mr. McLeod has raised this particular argument, although my motion says it was inartfully pled. It's a very simple argument. It's very basic. The problem is that when he's raised it in the context of like 40 pages of string citations and all sorts of just wild handwritten stuff. That's why I filed the motion, is because the motion is easy to understand. And I'll go back to the Kelly opinion. The Kelly opinion specifically says, if the legislature intended the police officers be permitted to manufacture crack or any controlled substance, and I'll throw in my own or any other law, before its possession or delivery, then such permission would presumably appear on the face of the statute. The legislature, if it intends to allow such practices, must expressly indicate their intent so that the courts can apply the law accordingly. At this time, however, there is no authority for the police to manufacture controlled substances by reconstitution or otherwise. At this time, the two-way communication device has zero language authorizing law enforcement to break that statute. And that's exactly what the language says. Any person, including law enforcement officers, acting under color of official authority. I mean, there is no carve-out for that. Our position is that this is a fundamental constitutional issue that can be raised at any time, and that therefore we are raising it, and I'm trying to strip away all of his extraneous arguments that he's ever made and present the court with the cleanest argument that I can, so the court can at least, if the court's going to deny the motion, deny it on the grounds that he's presented, as opposed to couching it in any sort of 3850 claims against his former attorney.
Okay, thank you. Mr. McLeod,
Yes, sir.
I want to read through everything. And so I'll give you my ruling as fast as I can. I know that next week is Christmas, but I'm hoping to get you my ruling before then, okay?
Yes, sir.
And I'll provide it to Mr. Kleins, and he'll get you that.
Yes, sir.
And Your Honor, I just would like clarification on one issue. I do believe that defense is required to put on evidence to prove an entrapment claim. So if we are going to proceed to a hearing on the entrapment claim, I think that would need to be set for another specific date.
Well, I'm sorry. What were you saying?
If you do prevail, you'll need to present evidence of the entrapment claim, so it would need to be set for another date.
That's fine.
That would be a separate hearing.
Right now, if we can put this on the February 13th docket.
Great.
A control date, at least. So
Okay, so just status on February 13th?
Yes, sir.
Okay, good. Thank you, sir.
I'll come see you next time.
May I approach?
Yes, sir. No, we're doing
This is
status
Tiffany Woodham,
February
State
13th.
Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Mr. Durrell, he doesn't object to that. So the court does grant that motion for continuance. How far do you want to set it out?
Just the next date.
February 13th? Okay, so February 13th at 9 o'clock. Well, does that need to be an afternoon hearing? Because it's going to be longer, Mr. Snow?
Yes, sir.
So February 13th at 2:30. Yes, ma'am.
This is Nazamara Herring with Mr. Lupella.
Good, thank you. Hello.
Sorry. Permission to approach, Your Honor?
Yes, sir.
This was set as a bond hearing, and I think we've reached an agreement. I have an order that's filled out, and I just want to make sure the court's okay with it.
Yes, sir. Thank you. Thank you, sir.
There's three issues that's in that order. One is the setting of the cash bond, which we're stipulating to. The second would be that her sentence would be modified to allow her to buy out the community service at $10 an hour for a total of $500. And that the third part of it is that the balance will be applied to her outstanding costs. She does have an additional $246.79 that she'll have to pay the probation before she'll be eligible for what would be auto termination of the probation. And we anticipate that that would be the case. We'll be set for an arraignment, but we might not have to come to arraignment if it's auto term in the interim. Trying to be efficient here.
Okay.
The 1515 is the amount of the rest, she's paid the restitution. She needs to pay the surcharge of probation and another fee to probation. The 1515 is the outstanding court costs and the community service balance added up together.
Okay. And so what will be left for Ms. Herring after this? Once she posts the cash bond, she'll be released from the jail.
Right.
She'll still be on supervision, on probation.
And she'd have to pay the $246.79 to probation directly. I would have put it in the bond, but it doesn't. I talked to probation and said, don't do that. So we're going to do it this way.
Okay.
Yes, she's aware.
Once that $200 is paid to probation, that'll trigger an automatic termination. She's been on probation, I think, for, was it close to 4 years?
Okay.
So this winds down everything.
Great. So, Ms. Herring, I just signed the order setting bond. So once you post that $1,515, then they'll let you out of jail, okay? If you get out today before 5 o'clock, you need to report to probation today. If it's after 5 o'clock, tomorrow morning at 8 o'clock.
Yes.
Okay? Thank you, ma'am.
Thank you.
Thank you, Mr. LaPella. Ms. Herring, one thing, Mr. LaPella, hold on one. Ms. Herring, one thing you didn't see is Mr. LaPella has been working the room since 9 o'clock this morning, making this work. So he's been working hard for you.
I appreciate it.
Yes, ma'am. Thank you, ma'am.
I missed my window when we walked outside, and then you had to take those other hearings. I was talking to Mr. Snell.
Okay.
So,
Yes, sir.
It's 1515, and I'll talk to Destiny about that.
We're going to do the 1230s next. I
Okay.
understand that they're not.
Okay, do we need probation here?
We have the 130 inmates. If we could take them, there's only a few of them after that.
Okay,
I don't know what will happen with them. So,
okay. So what did you say about 12:30?
we can go ahead and take those because I understand one's going to be a bond hearing and one's just a continuance.
Okay. Yes, ma'am.
Yeah, for the 1230.
I'm deliverance first. Come on.
Merry Christmas, John.
Thank you, sir. Merry Christmas. Now. Applying toward the cost, probation.
So there's no cash on it at this stage.
Right, it's just the one she's putting up now, 15.
So as soon as we receive the cash bond.
And that amount will be applied toward her outstanding costs.
currently here for a UP today.
She had to be here for something, so I suspect so.
So was she being sentenced today to modifying the probation?
Mr. Snell, the clerk's asking me questions on the last case. Yes, please.
So she was here today for the bond hearing, but she's also in VOP status?
Good morning.
Because she hasn't been
Morning.
arraigned on her VOP. We just received proof of service 3 days ago, so it will be set for a VOP.
Single point, you can send Mr. McCullough back up when he gets time.
Because if, so she's being sentenced, and then she's being sentenced today? Like she's taken the,
No, she would be entering a denial,
okay.
and then that's a bond, and then she gets out. We're gonna apply the cash bond as much as we can. Single requirement.
So we will not be
Hi,
able
this is
to
Alex
release
Berthe from
any
the
bonds
UPS
of
store
any sort until
in Crestview, Florida. We also have Eglin Air Force Base and Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to a deployed man or woman, to APOs, FPOs, I would suggest getting the mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy Christmas as well. In other parts of the U.S., you can also refer to the post office's website for those particular locations. Shipping outside the U.S., give it time. So again, sooner is better. On behalf of your Crestview, Eglin Air Force Base, and Fort Walton UPS stores, we want to wish each and every one of you a very Merry Christmas and a prosperous New Year's. If you need any help, come into any of our stores and we'll be glad to help you. All right, see you next year.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Mr. Lambert's on which docket? 12:30. Okay. Let me get that folder. Yes, sir. Yes, sir. Got it.
This case was continued from last Thursday's pretrial detention docket. I believe Mr. Gomez is going to be asking for a bond.
Yes, Your Honor. We're not going to be able to move forward with the pretrial detention. The officer who performed the search is part-time and he's not available. So we are going to be asking for a bond, Your Honor. I'm not quite certain which way the counts are. I don't know which number goes with which charge, so I'm just going to say the charge and the amount.
Okay.
On the trafficking in fentanyl 4 to 14 grams, Your Honor, we would request $150,000 cash professional. On the fraudulent impersonation, we would request a $2,500 cash professional. On the narcotics, or POP, I would request a $1,000 signature. On the license plate, not a sign, $1,000 signature. On the improper vehicle registration, $1,000 signature. And on the DWLSR HTO, $5,000 cash professional. I'm not going to rehash in any sort of at length about the severity of fentanyl, Your Honor. In this particular case, the fentanyl was found in the, I believe, right front pocket or right pocket of the defendant. This was after he had tried to give, I believe, his brother's name to law enforcement. Looking through the criminal history, admittedly, Your Honor, there's really nothing more than POCS and POPs. There's quite a few POCS, POPs, and DWLSRs. It's very clear that this defendant should not be driving, Your Honor. There's also a few FTAs. Admittedly, those are in 2018, and they're misdemeanor FTAs, so it has been some time. But this bond that we're asking for, primarily with the trafficking in fentanyl, is given because of the severity of the charge. I believe it's going to end up being around 12 grams of suspected fentanyl that was in the right front pocket of the defendant, Your Honor. That was found, again, after he tried to give somebody else's name. So for those reasons, Your Honor, we're going to respectfully request the bond amounts that were stated earlier.
So when was the most recent failure to appear?
2018, Your Honor.
Okay, thank you. Mr. Kleins?
Your Honor, I was actually telling Mr. Lambert that I was going to be asking the court for signature bonds on all of the non-trafficking allegations. So anything he's asking for a signature bond on, we're on board with that. We would ask the court to consider $5,000 signature bond on the driving while license suspended. I actually looked at his previous record too. I do concur with Mr. Gomez that Mr. Lambert probably needs to cool it behind the wheel. But his priors do show a pattern of possessions and paraphernalias and driving issues. We would ask for a $2,500 signature on the false name to law enforcement. At least as it's currently written, that's a misdemeanor. There's no allegation that it affected anybody else. As for the trafficking, Your Honor, we are going to ask the court for a $50,000 cash or professional bond. That is a high bond for pretty much anybody to try to make. The report's all we really have to go on. It says 13.5 grams with the weight of the baggie. I don't really know what kind of a bag this is. I don't know how heavy it is. I mean, it's clearly not going to take 10 grams off the weight, but sometimes some bags are heavier than others. That's all we can really do at this point is we're acknowledging the seriousness of the charge here. We are asking the court for a $50,000 bond on that. I don't even know if Mr. Lambert could afford it, but it would at least be something he realistically might be able to put together, maybe. And I really have nothing else to add. I mean, he's been in the area for a while, I will say that. I mean, his criminal record, it does seem to all come out of Okaloosa County. So if the court is hesitant or in any way wants a little bit more assurances, Mr. Lambert would be okay with being placed on weekly in-person pretrial reporting. And if it's a real close call and the court's on the fence, he would be okay with community control sanctions if that's what's concerning the court. I don't really think there's a lot of concern about is he going to show up or is he going to disappear. I mean, he seems to be from this area. So.
Okay, thank you. Mr. Lambert, I'm going to set your bonds as follows. In the driving while license suspended, it's habitual. Is that correct?
Yes, Your Honor.
Going to set it at $5,000 cash or professional. No registration, $1,000 signature. Attached tag not assigned, $1,000 signature. Possession of paraphernalia, $1,000 cash or professional. False ID to law enforcement, $5,000 cash or professional. And the trafficking in fentanyl at $150,000 cash or professional. So if you post that, they'll let you out of jail. Well, Mr. Lambert, is he on January 13th?
January 16th for arraignment.
Okay. You'll appear in front of Judge Stone next month. Thank you.
Next is Kevin McNamara, he's also on the 12:30.
Okay, thank you.
Your Honor, this is Mr. McNamara. This is a 2-day-old arrest. I believe the state, I'll turn it over to Mr. Gomez.
Yes, Your Honor, we're going to be requesting a continuance, I believe, to December 26th of 2024. I've already spoken with the victim. And I'm sorry, yeah, did I say the right date? Yeah, December 26th of 2024 at 12:30, Your Honor. We did just get, I believe my office received the information at around like 4 p.m. or 4:15 yesterday. And so we'll be likely seeking pretrial detention next week on that. If something were to change, then I'll definitely try to let Mr. Clens know, and if we can get some sort of stipulated bond amount, then we will do that if that's the route that we end up going, Your Honor.
Okay. Mr. McNamara, I'll see you a week from today. Thank you, sir.
Next, we'll go to the 1-3 docket. Joseph Martin will be first. Mr. Klein.
Your Honor, this is Mr. Joseph Martin in 24 CF 2670. We have 2-count information. We will waive the formal reading, enter a not guilty plea. I did talk with Mr. Gomez. I believe the state's going to be in a position to agree to reduce the bonds to signature bonds at this point.
That's correct, Your Honor.
Okay, so Mr. Martin, your bonds are reduced to signature bonds. That means that you'll be able to sign out of jail today without putting forth any money. Make sure you stay in touch with Mr. Kleins. Is Mr. Martin's, is it January 13th?
All right, that's for you.
It will be, Your Honor, as long as he stays out of custody.
I'll see you on the 13th. Yes, Your Honor, we'll leave it on the January 13th docket.
Thank you.
And I just gave Mr. Martin notice of that date and time.
Thank you.
Charles Solis is next.
Your Honor, I believe that's all I have. Maybe excused.
Yes, sir, thank you.
Judge, I'll see you this afternoon.
Yes, sir, okay. Yes, sir.
Your Honor, we're here in 24 CF 2612, Mr. Solis. Receiving the information, I did forward the state. There is a drop request in this. My client does have 2 other pending cases in front of this court, Your Honor. So today we will be entering a not guilty, waive formal reading. But speaking with the state, I may have them on the Thursday docket for a global resolution, and it gives them time to reach out to alleged victim in this matter.
Good. So if I don't see you a week from today, then you'll appear in front of Judge Stone on either January 13th or January 15th. But hopefully I'll see you in a week. Okay? Thank you, sir.
You're welcome.
Gregory Sudo is next.
Thank you. Hello, Mr. Sudo.
Your Honor, may I have a brief moment?
Yes, sir.
Sign right there. In front of the judge. Thank you, Your Honor.
Yes, sir.
This will be a change of plea this afternoon. It will be, count 1 will be a withhold of adjudication, 3 years of standard probation, $40 per month cost supervision. There's 24 hours of community service, substance abuse evaluation, and any recommended treatment. Maintain gainful employment or submit 3 job applications per week. There's no possession or consumption of alcohol, no possession or consumption of drugs without a valid prescription, random breath test, random urinalysis, $615 in court costs, $150 in defense costs. Count 2 will be adjudication of guilt. That's on the misdemeanor, and credit for time served. If I may approach with the plea form.
Yes, sir. Mr. Sudo, if you'll raise your right hand, thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you. You can put your hand down. Mr. Sudo, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Not thoroughly, but yes, I did read it.
Okay.
Like,
Do-
I'm not that great of reading and writing.
Okay. Did you understand everything that Mr. Koch said today?
Yes, Your Honor.
Do you agree to that?
Yes, Your Honor.
Do you understand that if I accept your plea, that you're waiving your right to a trial by jury?
Yes, Your Honor.
You have any questions for me or Mr. Koch?
No, Your Honor, but I do have a little problem of myself. I have gout and arthritis problems, so like finding jobs and having jobs is kind of hard for me.
Yes,
And I just had an operation on my hand like 2 months ago, and I do take medication daily, and I can't have that in this, so I can't get any jobs. I tried going to get jobs, but due to my gout and arthritis on my feet, so I can't stand for so long.
Understand. And you just have to do the 3 applications per week until you gain gainful employment. But as far as medications, you have to be on medications now. Well, you can't be on any medications unless they're prescribed.
Yes, my medications are prescribed, Your Honor.
Good, okay. So, Mr. Sudo, I do accept your plea. Adjudication is withheld in count 1. You're sentenced to 3 years probation. You'll need to perform 40 hours of community service work. No, 24 hours of community service work. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You need to gain employment or perform 3 job searches per week. You'll have no alcohol. You'll have no drugs without a valid prescription. You'll submit to random urinalysis and random blood tests.
Yes, Your Honor.
You'll need to pay the court costs, $150 public defender's fee, the $40 per month cost of supervision. But Mr. Sudo, how long have you been unemployed?
It's been more than 7 years now. Your Honor.
Okay. So, Mr. Sudo, I do waive the cost of supervision for the first year. As you get close to the end of that year, if you still don't have a job, file something with the court and ask for that to be extended, okay?
Yes, Your Honor.
Thank you, sir. Good luck to you. Yes, sir.
Your Honor, if we just clarify the record, I believe you stated random blood test. It was random breath test.
Thank you. Random breath and random urinalysis. And count 2 is an adjudication of guilt and time, sir.
Thank you,
Thank you.
Judge.
I knew that sounded funny when I said it. Thank you.
Your Honor.
Justin Tipton's next.
Thank you.
Thank you. Yes, sir.
Hello, Mr. Tipton.
Just mention a brief moment.
Certainly.
Thank you, Your Honor.
Yes, sir.
This is Mr. Tipton in 24 CF 2217. We'll be entering not guilty this morning, a waive formal reading, and all his cases are set on the trial docket, Your Honor.
Okay. Mr. Tipton, you'll be in front of Judge Stone. If you're still in custody, it'll be January 15th. If you're out of custody, you need to be here on January 13th at 9 o'clock. Okay? Thank you, sir.
Thanks.
Jody Wolf is last. She has no attorney right now.
Okay, thank you. Ms. Wolf's case number is 24 CF 2640. To the state, do you have any update on Ms. Wolf?
I do not know the status of that.
Okay. Ms. Wolf, do you want me to appoint the public defender if you qualify financially?
Yes.
Okay. How much money do you average making per month?
Like 900.
Okay. I do appoint the public defender to represent you. Mr. Koch is approaching on your right.
Okay.
Do we have the formal charges?
I'm gonna try to
Okay.
get the information before we come back after a while. I'll try to call up with the jail and see what the status is.
Okay. So there isn't an information file? Okay. So then we set Ms. Wolf for the next arraignment date? Is that accurate?
Yes, sir.
Okay, let's see. I think I heard the 16th. So January 16th at 1:30. However, Ms. Wolf, the state will do some research, and if they can resolve it before then Mr. Koch will stay on your case. If you need me, I'll be back here a week from today. So hopefully they'll work it out, okay? If not, then you'll appear in front of Judge Stone on January 16th.
Okay, I was hoping to go home. My brother's gonna get me an attorney and stuff to
Okay.
take care of all this, so.
Good, good. If they don't work it out before that, then your attorney can do it.
Okay.
Thank you, ma'am.
That next one. Yes, ma'am.
Thank you.
Would we like to also continue the pretrial conference to the March date since it's the felony plea days after?
Yes,
Yes,
ma'am.
please.
That'd be a good
Thank
idea.
you.
This case is set for 3/8, she said, right? That would- Okay.
Set for January 16th arraignment. Right.
So everything's sorted as far as hospitals?
That's my offer. I don't know if it's everything's clear.
That's all you got? Okay. So we've got to come back at 1:30 because we have some folks that aren't incarcerated at 1:30. And 2:30, do